Please give whatever. It will be taken up serially. Don't worry. It's called.
One, my lord, I am for
Why
the,
to be mentioned?
yes, my lord, I am for the appellant led by Mr. Rai, my lord. My lord, it is dismissed for default in the Honorable Division Bench, sitting on Logima, taking on Logima matter. That's why I filed this application before the Division Bench, my
Then
lord.
it will appear as a application.
My lord, one difficulty is there, my lord. One restoration application has been filed in the year 2009. I have checked the file.
Whatever.
There is no such order reflecting that that has been restored. And my lord, that once again
The matter has wrongly appeared under the heading to be mentioned, though ought to have appeared under the heading application. Oh, Jani, the matter has wrongly appeared under the heading to be mentioned today. It appears that the application is required to be heard by this court, and therefore let the applications be listed on the next date.
my lord, may I pray one thing, my lord? I have lost my application of 2009 application. May I take a copy from the department by applying the same, my lord?
Like
Deep level, sir.
to
Your Lordship, I appear for the appellant in this matter. This is a matter which pertains to dismissal of the money suit filed by an unregistered partnership firm, Your Lordship. On the earlier occasion, on 25th August, Your Lordship was pleased to direct the appellant to deposit special messenger cost for bringing the lower court records.
have you put in?
Yes, Your Lordship, on 30th August, within a week from date of order.
Which court?
Yes, Your Lordship.
Which court?
Uttar Dinajpur, Senior Civil Judge, Senior Division, Uttar Dinajpur.
Seen the note of the office dated 5/3/2024. It appears that despite the communication having been made for sending the lower court record, a plea has been taken that the record is not traceable. However, more time was sought for, which appears to have been given, yet the record has not arrived to this court. The London District Judge, Uttar Dinajpur, is directed to submit the report from the concerned department as to why the lower court record is missing, and fix the responsibility on the person who was in the helm of affairs. In addition to the same, in addition to the same, the London District Judge is directed to ensure that the lower court record is traced out and sent to this court immediately.
I'm grateful, Your Lordship.
Whatever, do it, send it.
This is an application for
Item number
3.
This is the Lavajima matter.
Yes, the matter has been dismissed by the Honorable Division Bench in for non-compliance of the direction. But Malat, the compliance has already been made. Malat, it can be appeared from the records itself. Malat, if your lordship kindly see the order dated 13 July 2023. it is recorded that although unfortunately I could not, my learned advocate on record could not present, and for non-compliance of the direction, it has been dismissed.
So,
Now, kindly come to.
can be done. The substitution application has not been taken out.
It has been filed. Kindly see the purple colored, pink color flag. So, immediately after the yellow flag, immediately pink color flag.
This is the pink color flag.
No. Front. Yes. Kindly see the application has been filed. Application as also the supplementary affidavit that has been filed.
Where is the application?
The application is CAN number 01 of 2019. Old number
4227.
4227.
You wanted a deletion of the name of the opposite party number 2 and
2,
3.
yes.
3 also died. No, sorry. Record the name of the plaintiff as the vice president.
Yes.
So right to sue survives upon the
Yes.
3.
Obviously, it is Hon'ble
Society.
So, abatement does not arise.
Before your last, these application for restoration has been filed.
Why you did not appear on the day when this order was recorded?
I missed
Why you did not appear on 13th of July?
I missed the matter in the list.
The matter?
And this application has been filed for restoration along with an application for condonation of delay.
Condonation of delay is CAN 3.
CAN 3, my lord.
Seen the order dated 13.
Hey.
Seen the order dated 13 July 2023, passed by the coordinate bench, indicating that no steps were taken for bringing the heirs and legal representatives of the deceased opposite party number 2. And therefore, the CO is required to be dismissed, which in fact has been dismissed by the court. Full stop. Where is the application for restoration of this appeal?
This is CAN number 2 of 2024.
2 of
2024.
CAN 2 is the application for restoration and CAN 3 is for the
condonation of delay in filing the application.
The instant application being CAN 2 of 2024 and CAN 3 of 2024 has been filed. Have been filed for restoration of the revisional application, which was dismissed on 13th July 2023 upon condonation of delay in taking out the same. After perusal of the averment, it appears from the averments made therein that an application for deleting the name of the opposite party number 2, who was holding the post of a vice president of the society, had already been filed, being CAN 4227 of 2019. Notunta dekhe. Stop. The court inadvertently proceeded to dismiss the application on the premise that no steps for substitution was taken by the petitioner, when in fact such steps had already been taken way back in the year 2019. In view of the above, and considering the explanation offered for delay in taking out the application for restoration of the original application, we are satisfied that the petitioners were prevented by sufficient cause in filing the aforesaid applications. Accordingly, both the applications are allowed. The delay in filing an application for restoration of the revisional application is hereby condoned. Consequently, the application for restoration is also allowed. The revisional application is restored to its original file and number. Let CAN 4227 of 2019 be listed before the appropriate bench. Next. Mr. Mukherjee, your matter cannot be taken up because of the because that was heard by Justice Prashad.
So, next Thursday?
Next Thursday, automatically.
This day week, madam? Grateful.
What is this? We can't because this was heard by the other bench. Where is Mr. Dutyman Banerjee? Yes, not this thing. তোমরা দেখো না এটা কিন্তু অর্ডার করার জন্য এটা ছিল কিন্তু don't call these for orders. They were all heard.
Item number 8, Lordship.
Another bench that was heard by the
Just only under order 41, Lordship.
but that was heard by the other bench. Why?
My lord, I appear on behalf of the appellant. My lord, I am praying, my lord, 1 week time, my lord. Your lordship was pleased to.
Sir, this is a 2019. 4 years have passed.
No, my lord.
FME,
My lord,
either remand or injunction. What?
my lord, your lordship, my lord, was pleased to heart, but this matter on 26th. Your lordship was pleased to direct to my lord serve copy. And I have sent, my lord, my lord, service is not complete. That's why I am praying, my
lord. Service is not complete. Let this matter appear after fortnight.
I am deeply obliged.
Skip. Give me the file. এটা কি অনেক দিন থেকে অ্যাপিয়ার করছে? হ্যাঁ? Nobody is appearing. Well. Good.
Should be contested. Degree should dismiss which. মানে কি হলো? Bilala ho. Judgment of reversal.
Somebody will come. এ কি অনেক দিন থেকে আসছে না? Before. Yes. Oh, so wait, don't record. Just pass over call. Pass. Well.
Yes, Mr. Bhattacharya.
Yes, but I would like to
translate the deed of settlement. I have translated the deed of settlement and in Bengali, the deed of settlement, I have brought that Bengali deed of settlement.
Now you can bring the original.
Yes. Yeah?
Now there is no difficulty.
No difficulty.
What is the
entire
matter
property-
about? What is the
But-
matter about?
That was settled by the
That was settled what? Matter about?
suit for partition. Suit for partitions.
You are the plaintiff or the defendant?
I am the defendant.
Defendant. The preliminary decree passed. Affirmed up to the appellate court. Judgment of affirmance.
Yes. Yes.
Affirmance.
Affirmative.
So you are a defendant. Why you are?
Entire property that was settled prior to the date of
What settled?
that has been settled. That what portion of it is there? That after his death, after the date of P.R.E. Mohan Niyogi, the entire property devolved upon the wife. After death of the wife, the first floor, entire first floor that will be allotted in favor of the defendant of one. And only the
How it devolved upon the wife alone if they have a children? I just wanted to know.
but entire property has been settled. It's a registered deed of document.
You said that the original owner, what Niyogi,
Yes,
he died
he died.
and his property devolved upon his wife. Whether he had a children, I just wanted.
Children.
So will it not devolve upon the children as well
Yes.
in equal share?
No, that is my submission because according to
Not
deed of
equal
settlement,
share.
deed of
Under
settlement
section 8 of
that has been settled. Mana dane trial that had
the original owner settled the property.
settled the property.
Deed of settlement was done.
Prior to
What?
his death, prior to his
Prior
death.
to death.
Obvious.
Prior to death. That is a deed of settlement.
Obviously.
Then he also directed to bring the deed of settlement exhibit A. Prior to settlement.
Learned trial, it has been exhibited before the learned trial court.
Yes, deed of because no, according to section 14, Hindu Succession Act, moment the wife property devolved upon the wife.
My brother is asking whether this deed of settlement was marked exhibit in the suit.
That I will
The
not.
only thing he wanted
Only
to
thing.
know.
So learned trial court failed to take cognizance of
Take
it.
cognizance.
And then why the appellate court?
Applicable of the section 14, yes? No?
What section 14?
Section 14, Hindu
Of the
Succession Act,
Hindu Succession Act.
Hindu-
14.1 or 14.2?
14.2.
14.2.
Now,
Tell us the exception. Where is
And
the
this-
judgment of Justice S.B. Sinha? On section 14.2. Where is the judgment?
but I have got one judgment, AIR 2008, that's a judgment of R.K. Agarwal and Abhay Mohan Sapre, where Mr. Ranbir Dan. But I hear that when the property has been already settled prior to his death, maybe that has been there during lifetime, the wife will enjoy the entire thing. After death of the wife, the property has already been settled.
If the limited interest is provided to the wife, will it not turn into an absolute interest under section 14?
Only the daughter,
What daughter?
only daughter, the suit has been filed by one of the son. He has also got on the basis of settlement also. He filed the suit for partition. He has not been deprived by the deed of settlement.
Oh. It's a deed of settlement is a mode of user.
Mode of user.
If it is a mode of user, then does it tantamount to partition?
But not only user, that it has been clear. You also can see the deed of settlement. After death of the wife, the son, elder son will get this property and elder son gets the but the so far the daughter is contract, he will not get anything. She will not get anything. The origin.
So there are two things. If the deprivation has come, so the nature of the document is to be ascertained. It may be styled as a deed of settlement,
Yes.
but it may be in the form of a will.
That is why you are asking that question to me also.
Yeah.
They bring that deed of that
It is a deed of partition between two brothers.
one brother files the suit for partition and daughter also has been included.
It has been stated is with regard to the rate of the rent. Is the rent. Distribution of the rent.
After years.
Nomenclature of the deed is not a determinate factor.
The village to high. Yes, correct. So it will take effect only upon my death. Is it? It's a will. Nomenclature is immaterial. Construction of a document has to be ascertained. So you are depriving a daughter. Aditya, sit here. 14 to the 2. That is a big problem.
ইয়াই আমার ইচ্ছা এবং কামনা।
Letters of administration with the will and
When page 3, it has been the condition, page 3. Page 3.
Sir, have you seen my judgment?
Your lordship judgment.
Yes. I have held that the nature of or the nomenclature of the deed is not a determinant factor.
Not a factor.
That was also a case of a deed of settlement. Then I said that the language and the contents of that deed is to be gone into for the purpose of construing the deed, nature of the deed. And if it says that all these will take effect on my death, then in that event, what will happen? Will it be construed as a will, or will it be construed as the immediate passing of the divestation of right? If it does not, then in that event, it will be regarded as a will. Go and have a probate. How can you deprive the daughter?
But in the court below, daughter did not contest, she did not come.
Sir,
Maybe.
immaterial in a partition suit,
Yes.
there is no concept of plaintiff or a defendant.
Yes.
When a court is passing a preliminary decree, the
Yes.
court will only pass the shares which held by the parties.
Then my
Nothing more than that.
My subject, because this document, it has no value. Only
No. There are, sir, that's why I said, please
then I
consult
shall
that
go to your
judgment of
lordship
Justice
judgment.
S.P. Sinha. What the Supreme Court has held in this regard. Supreme Court has said that even there is a document, maybe styled as a family arrangement, family settlement, or whatever. But the parties, if they come for a partition,
Yes.
it loses its effect because it does not sever the properties by metes and bound as required under the Partition Act. It is only an exclusive mode of user of the joint property. So even if at the time of if the final decree is passed, the court will definitely respect that the respective position should not be disturbed. That is what an equitable distribution in a final decree. Will try to keep the position undisturbed.
But then I shall come.
Kindly consider you are depriving the daughter. Daughter may not have come.
Yes.
But the law says that under section 8 of the Hindu Succession Act, if it is an interstate succession, then the daughter is a class 1 heir, along with the mother and the brother.
Along with the mother and the brother.
And brother, daughter is.
The moment the father died.
Obviously, section 8 says so. Should I have to remind
Yes,
you?
no, I know. Section 8, I know.
Class 1 heir, the daughter is not a class 1 heir. Equally entitled, same share. And that might have been held in the preliminary decree. I have not opened the brief as of now.
But can you see the appeal court judgment? You have not gone through it.
It's true.
Previously, you have not gone through it.
That appears to be a correct approach.
But after hearing me, your lordship only asked me, yes, to bring the exhibit A, that is the deed of settlement.
That is a different. We wanted to look at the nature. We have seen. It amar only ichha or kavana.
No, both the learned trial court
Yes.
and the first appellate court have come to a concurrent finding that so far this family settlement is concerned, right, title and interest has been created in favor of the wife of the settler, not in favor of the sons and daughters of the settlers.
Yes.
These are the concurrent findings.
Concurrent finding.
What materials you have to show before us that it is in fact intended to be created title or interest in favor of the sons only also.
And can you see page 3, the deed of settlement? Page 3.
What
I
is?
shall go to your lordship judgment. Can you get page 3?
Yes.
And one page 3. আমার দুই ছেলে,
Oh, very good. That's true.
and has gone through it.
Yes.
That's true. I have seen that.
But Bengali didn't. You have not gone through it. Just today I am to
আমার মৃত্যুর পর
আমার
উক্ত সম্পত্তি আমার স্ত্রী শ্রীমতী বিনা নিয়োগী একক প্রাপ্ত হইবে।
yes.
What does it mean?
আমার I
I
have
have seen. I have already read 3 lines.
It has been underlined by Justice Tandon. আমার মৃত্যুর পর উক্ত সম্পত্তি আমার স্ত্রী শ্রীমতী বিনা নিয়োগী এককভাবে প্রাপ্ত হইবে।
What does it mean?
they
The
মালিক
property will devolve upon such and such.
yes.
আমার মৃত্যুর পর।
আমার মৃত্যুর পর
What does it
thereafter after death of my wife
mean?
were paid-
পাইবেন।
page
That is
5
what, yes, পাইবেন। And then he said, this is এটা আমার অন্তিম ইচ্ছা আর common. This is my last wish and
In
desire.
case of a deed of gift or deed of settlement, title passes at once.
yes.
But in case of a will, title passes after the death, subject to the grant of probate or letters of administration, whatever may be.
Well, I may be wrong on this judgment but I have brought.
Please.
That is it.
How to be wrong? Let us see. We may be
It
wrong.
is
Let us see.
it is in there.
এই ফাইলটা দিন।
Paragraph
Substance.
39
That is what I am saying. I
Yes.
agree with this. That the restrictive right
yes.
has really ripened into an absolute right. Now consider the situation, sir. The mother is not alive,
But page 44 paragraph
sir. Let us proceed on the basis of your case, hypothetical, which is not correct. Still, let us treat. If this is construed that he has created an absolute right into the wife, has the wife left will?
no.
If the wife also died, which in this case must have, because that is a very old document,
Rolled over.
not alive. Then under section 15 of the Hindu Succession Act, daughter is excluded. How can you claim an absolute right? Let us proceed.
But can you see this?
There are two concepts. 14.1, limited right,
Yes.
converted into an absolute right.
Yes.
Correct? If the absolute right is there into a wife, let us consider. Then in that event, upon her death, all the children will get it under section 15. If it does not convert into an absolute right. Exception under section 14.2.
40 yes.
Correct? She had a limited right throughout her life.
Yes.
How the sons get the absolute right? She only was holding a limited right. Then how the sons get an absolute right? That too, because so long she is alive, the sons will not get it.
No, so some will not get.
So
But it has been settled. My act.
that is what I am saying. Settled means the settled immediately. If the language, that is what my judgment comes. If the language of the document says that it will take effect in the future, and there is certain things which are also there, then in that event, it is a duty of the court to construe the document. If it appears that the document is styled as a will, then it is to be considered as a
Will.
which appears to be so in this case. You were harping something else, 14.1, 14.2. So that's why we asked this deed to be produced. And now we have seen the deed. Nothing.
But this judgment will help me. I don't know what.
No, this was a different one. Have you seen that?
But
I'm saying relying on this. Let us see. You say that it comes under an exception, 14.2, not 14.1.
Yes.
Correct? Let us proceed. 14.2. Then she had a limited right. After her death, what would happen? Yes. that limited right has not ripened into an absolute right.
No.
Correct? Because you are taking shelter under 14(1).
But
then the children will get it. They can, if you say 14.
that is, you dispose of the property.
Be resilient to your sister. Okay? Don't take up all the things. Both the courts have concurrently held that the plaintiff and the defendants have a share in the scope of the joint property in equal share. Equally. On the death of the predecessor, in bypassing the plenary. Admittedly, the property belonged to the father of the plaintiff and the defendants, who during his lifetime executed a deed is styled as the deed of settlement. Sorry, it is styled as the deed of family settlement, which was duly registered with the registry. After the death of the father, and upon the death of the mother, the instant suit came to be filed, seeking separation of the shares on partition. A plea sought to be taken that the said deed of family settlement indicates that the mother was given a limited right on the death of the settler, and on her death, it will go to the respective sons. Both the courts have held that the said deed of settlement, the family settlement,
That you can see.
judgment of reversal.
No, judgment of affirmation.
What does it mean?
Court has dismissed the suit. It says that is bad for misjoinder.
No, the suit was
Interesting.
degreed.
It was degree.
No, but this is
Their appeal was dismissed.
really, I'm surprised with this, where the judge has
In the
No, trial court judgment, page 9.
I'm looking at the trial court judgment. That's why that affirmation has come.
Suit is page 9.
It is not bad for non-joiner.
Suit degree
No, if you come to page 4 of the internal page 4 of the judgment,
is internal page 4 of a trial court judgment.
last paragraph, hence,
No, it is the case of the defendant. WS.
oh, decision with reason.
Yes.
Sorry.
Defendant has not initiated any share.
No, that is the defendant's case in WS.
Defendant. Defendant.
Not bad for non-joiner, misjoiner.
So degree.
That the deed of a family settlement cannot be regarded as immediate divestition of right title and interest by the settler, or akin to a deed of gift. So it is further held that the intention of the settler can be gathered from the language employed there, which would indicate that an arrangement was made for the user of the respective portions of the joint property. Which cannot be regarded as a partition or the separation amongst the sons. A plea was sought to be taken that the limited interests created by virtue of the deed of a family settlement in favor of the wife was not affected by virtue of section 14 within bracket 1 of the Succession Act, but comes within the purview of section 14 within bracket 2 of the said Act. And therefore, upon the death of the limited interests created in favor of the mother, the property passes on to the sons and not to the daughter. The court disbelieved the opposite contention that it is not a case of creating a limited interest and upon the death of the mother, it would pass on to the heirs under the law of succession. Next one. Mr. Bhattacharya, the learned advocate appearing for the appellant, vociferously submits that the mother cannot claim an absolute estate if the right is created by virtue of a document styled as the deed of family settlement. And therefore, in absence of any share in respect of a joint property, there is no question of devolution of her interests into the class 1 heirs under section 15 of the said Act. In support of the opposite contention, the reliance is placed upon a judgment of the apex court in case of Mr. Ranveer Deva versus Mrs. Rashmi Khanna and another, reported in
AIR 2018 Supreme Court. What is this? Page 82 or 62?
62.
Reported in 2018, volume 12, SCC, page 1. The admitted owner executed a deed of will. Executed a will bequeathing his movable and immovable properties, which further provides that the ground floor of the immovable property will go to one of his sons exclusively, whereas the first floor to his daughter. However, the interest of the widow was restricted to a life interest with the right to reside in the property till her death.
To recover rent.
She was also permitted to recover the rent and the other usufruct of the said properties to her exclusive use and enjoyment, with an additional right to take all steps for recovery of possession from the tenants. Since the word life interest was used in the said deed, it was sought to be contended that she was in effect enjoying the status of a trustee of its legal heirs, and subsequent dispositions by the son is improper. The court, after considering held that in order to attract the provisions contained under subsection 1 of section 14 of the Act, one of the seminal aspect required to be considered is that the person must have a pre-existing right in absence of the pre-existing right. It would cover and come within the purview of within the ambit of section 14(2) of the said Act. There is no quarrel to the proposition of law as laid down in the said report relied upon by Mr. Bodger. But the question which begging an answer is whether the purported deed of family settlement is in the nature of a gift or a will. Stop. It appears from the language employed in the said application, in the said deed of family settlement, that though the life interest was sought to be created in favor of the mother by the father, but such interest would take effect after his death, and even the right of the sons were not created in presenti, but to have been created on the death of the life interest holder. Even if we construe the same to have come within the purview of section 14.2, yet the effect of the deed does not evince the passing of the right title and interests in favor of the sons, but can at best be regarded as a will to take effect after his death. Stop. Both the courts have found that the instant case does not come both the courts have found that the purport of the deeds does not indicate any exceptions to be carved out, nor any case has been made out which would lead to an inescapable conclusion that an interest is created into the persons immediately upon the execution of thereof, and therefore, in absence of any recognition or giving sanctity to the wish and the desire of the settler, the property would still be regarded to have passed on by virtue of the provisions contained in under the Hindu Succession Act. Stop. Precisely for such reason, the plea of the defendants that the suit is bad for misgender or party was turned down. Stop. From whatever angle we look at, do not find any involvement of the substantial question of law in the instant appeal. The appeal is dismissed under Order 41, Rule 11 of the court. No order is proposed.
This is good.
Yes, call the next. Okay. You know.
I am for the caveat one.
I am for the appellant.
You are appearing for?
Appellant matter.
I am for the caveat one.
First, tell us who are you in the trial court, plaintiff or defendant?
We are for the defendant, my lord, defendant.
Judgment of affirmance or reversal?
No, judgment is here. Both the judgment are
affirmance. Judgment of affirmance. And what is the nature of the suit?
Suit, my lord, suit for declaration
of
declaration and title.
Declaration of title or declaration of deed to be void or what?
No.
Declaration of elementary right.
Declaration
of title.
Yes, my lord.
Tell us that.
My losses can come. To my, I have filed the plaint also there, my lord, in my stay application.
No, it's not.
So,
tell us what is a case about made out against you.
And the plaint, my lord,
not still tell us.
They have paid for, my lord, plaintiff paid for permanent scheduled property against the defendant number 1, permanent injunction.
No,
title. The possession of the petitioner and plaintiff performer respondent.
Sir, please, this is not a way to argue second appeal. I am asking you what is the fact which has been pleaded in the plaint. Nutshell, can you give me?
But that is my first he has stated that the land in question, which my land.
Suit for permanent injunction without taking any declaration.
He says declaration.
No, the suit for injunction only.
Suit for injunction.
My God.
And my lord, what happened, my lord?
You have not read your brief, sir. You said title
I asked you what is that title. You said declaration. I said declaration of title. You said yes.
It was a suit praying for
If-
permanent injunction,
Injunction.
restraining the defendants from interfering with their possession and
Now,
not from changing the nature and character of the
correct.
property.
Now tell us that the plaintiff is not in possession.
Plaintiff in
That's the
possession
only point.
of his land. Of his land. He is asking
A
for
scheduled property, not a office land. It is a scheduled property.
scheduled property A.
Plus,
Scheduled
tell us
property
that
A.
the plaintiff is not in possession of the scheduled property.
Scheduled property A.
Right.
And I am owner of the scheduled property B. That is called as a non-Julie. Non-Julie, that is malad. And in appeal court,
Sir, take a rest a while. Let us go through the papers ourselves.
malad.
Just take a rest a while.
Malad.
We'll take it. Don't.
And in
It
appeal
is
court,
better.
malad, they have
No, it is better to go.
Just a minute.
malad.
Just take your seat.
And in short, I am saying malad.
Nothing. That would create more confusion.
রহমানের নামটা লিখুন। Well, they filed case saying that the land in question, that is P scheduled property, belongs to government. And that pair is injunction not to disturb their position in A scheduled property. That is fair.
So far as a scheduled property is concerned, what is your stand? The
That is that-
observation of the learned trial courts and the first appellate.
With him. But that with the plaintiff, we are not objecting.
Very good.
Our is.
What is your contention with regard to schedule B property?
It will be ours. They said, they filed case saying that it is government land. Government came and in evidence they have said it is a property of the defendant, private.
Oh, just reverse.
It has been acquired by government.
The government says in
that is there is human
1963
It is not
acquisition
matter.
proceeding,
Huh?
1963
Losses
acquisition
can
proceeding,
come.
the
Matlab-
government has said that the entire property, B scheduled property has been acquired
Not.
for the purpose of
Government
this.
said not, Manlat. Government said not.
What are you talking about?
Appeal court has not recorded the submission of the defendant. Losses can be.
No, it has said, sir.
Come
it has
to
said-
page 18 of the trial court judgment.
Yes, Manlat.
Page 18 of the trial court judgment. Second line from the top.
Manlat. And losses can come to page 4 at first.
No, page 18. Please read.
Yes, yes.
Page
Page
4 is
18.
your stand.
Page
18 is a
page
finding.
18 of the learned trial court's order. Judgment.
Yes.
1-8.
One at Manlat.
Internal of page 1-8.
Manlat. That is the property being 9th decimal of the land.
No, sir.
But
What
again,
starts with now inter alia. Second line.
Second line from page 18.
So page 18, second line.
Will I read from this?
Just a minute. Sir.
Hello, Lordship, kindly come to page 15.
Only finding is যেটা ওখানে এসছে পেজ 11 এর bottom they update করছে দিয়েছে
Internal page 11.
at the bottom
বসো না বসতে বলে তুমি দাঁড়িয়ে থাকো। This is very bad.
appellate court judgment. Appellate court judgment. Not trial court.
Appellate court judgment is here.
Appellate court judgment.
Will I read the government evidence or not?
Huh.
Evidence of the VLRO and the PWD. They said non-Julie is not our. We scheduled property not our.
Just a minute.
This is the finding, only finding that can be.
An appeal court has not discussed about the our here.
এটা আছে সেই জন্য বলছি
Well, Lordship, can you see page from the page 14, Lordship will get page 15, the evidence of the defendants, including the government.
Exhibit PW7, 8.
It is their case, my lord, that I am forcefully occupying the government land. But government said, no, it is my land.
What?
Government obviously evidence said, it is my land, the hardware in my name.
No, this is, sir, the appellate court has said that the PW7, 8, 9, and 10, they are all the government officials.
My lord.
They have come and straight away said that these are all the entire B schedule property has been acquired by a government.
That is not correct, my lord.
Show us that this finding is a perverse one. We will admit
15
on
I'm
that
reading.
score. Please show us the evidence of the PW7, 8, 9, 10 that they have not said that the entire B schedule property has been acquired.
And their oral evidence is their oral evidence gets sufficient corroboration from Exhibit 9. That is the acquisition map.
Well, the
acquisition
so-
notice
well,
and
lord, can come
certificate.
page 15 of the evidence.
That is
Recorded, page
erroneously-
15 recorded.
erroneously appearing in the name of the private party. That does not mean that the right has been created.
No.
The scheduled paper is our that is said by the government.
So
May I read
please
the
show
judgment
us
today?
the evidence.
That is evidence, perhaps not with me. Well, then
Not with me. What are you talking? We will go by a sanctity of the finding made by the court.
then
Sorry.
well, adjourn it, well,
We will not believe the statement at the bar.
from the evidence recorded in the trial court.
Sorry.
Trial court has not recorded our submission.
Please,
our submission before the trial
Mr.
court.
Counsel, please come to page 12 of the appellate court judgment.
Appellate court
You are
also-
contradicting it. You have to show it. Please come to page 12 of the appellate court judgment.
that is contradiction in the trial court judgment, lordship shall get.
Or better come from bottom of paragraph page 11. Come.
Page 11, my lord.
Yes, bottom. 3 lines from the bottom. It starts Exhibit 4.
If in our
Exhibit 4
property is
is
government.
the land acquisition plan map. Have you got that?
Yes, my lord.
And the
And which was
position
acquired
certificate.
the state purpose of the Pakka road. That is, my lord, the submission of the plaintiff.
No. Please. This is what it says. The plaintiff in her plaint stated that B scheduled property is a government land
Right.
which was acquired for the purpose of Pakka road from Devogram to Tehta. That was his submission.
My lord.
Then the finding is Exhibit 4 is the land acquisition plan map and the possession certificate. Exhibit 9 is also the acquisition map, acquisition notice and possession certificate. And from those documents, it reveals, that's the finding of the appellate court, it reveals that the B scheduled property was acquired by the government of West Bengal, V-Day notification number such and such, dated 18/12/1963 for the purpose of construction of a Pakka road from Devgram to Tehto. And from those documents, it reveals that entire 19 decimal of land in plot 1020 of 1028, Batadag, was acquired and the government took possession accordingly. At present, the plot number 1202, 1208, Batadag, is classified as Nyanjuli, is situated adjacent to the metal road. But
My lord.
the learned advocate for the plaintiff has submitted. Now he says, but that's a finding of the trial court. Then says, but the learned advocate for the plaintiff has submitted that due to the ignorance of the government, LR record, it still exists in the name of some private party. So what he says is that all these acquisition the court found was there, but it was wrongly recorded. Learned advocate for the plaintiff has further submitted the PW 7, 8, 9, 10, all government officials. And during their examination, it stated that the government has acquired the entire B scheduled
That is not
property
correct. Record,
for
my
the
lord.
purpose of
That is not
making
correct
road.
record.
So,
Why?
so what about Exhibit 4? What
What
about Exhibit 9?
para 15 up
Sir,
to
same,
para-
just a minute, sir. Same is the version of the learned trial court. Now, inter alia, the plaintiff has submitted the acquisition map of the Devogram Theater Road, marked Exhibit 4, and the map along with certificate of possession, marked Exhibit 9, which shows that the said BCDUL suit property was indeed acquired by state via PWD department. PWD.
One thing, my lord.
Inquiry report of the BLRO along with annexure indicates that the plot of the plaintiff is situated right. That is different thing. So these are concurrent finding with regard to the title of this Schedule 3 property.
May I submit, my lord, the evidence of the government officers? That is recorded.
Show us the evidence. Show us that this finding is perverse. I'm
My lord,
inviting your attention, sir.
my lord, the appeal court, I am submitting on the appeal court has not recorded our submission before the
It is not required.
evidence.
Sir,
Only has recorded
The
plaintiff's submission.
art of writing a judgment differs from a
Man to man.
particular man to a man. What he has said that he relied upon certain exhibits, and those exhibits, according to them, appears to be really clinching an issue.
My lord, may I read, my lord, from the defendant case, page 4 of the trial court. My lord, I am reading.
Sir, I want an evidence. Show us that this finding of the appellate court and the trial court
Then, my lord, the
perverse.
lordship adjourned, I will bring it, my
Not
lord.
a-
My
not-
lord, can you come
not-
to them page 4?
Sir, will not do.
One thing, my lord, his prayer is not to disturb his possession. Injunction, that is, my lord, injunction to that effect. In a scheduled property, the court is gave judgment about the ingression and case. That is
Has
not the
to be,
pair.
sir.
That is not the pair, my lord.
No, that is what is the mandatory injunction on Schedule B.
Schedule, my lord, not to disturb my PF.
One is a permanent injunction in Schedule A and the mandatory injunction in Schedule B.
My lord, a decree should be permanent injunction in respect of the Schedule A property
And mandatory
against the
injunction.
defendant number 1 to 7, restraining them from interfering into the peaceful possession of the plaintiff and performer defendant in a scheduled property.
Because
A scheduled property, I am not
a
disturbing.
scheduled property,
Hmm.
to access a scheduled property, he has to cross the scheduled property on which you are creating obstruction.
No, my lord, that is not the pair. First thing. The second thing is, my lord,
Defendant
that
numbers
you-
1
B
to
scheduled
7,
property is
8 and
mine.
9 are further directed to clear up the obstruction from the B scheduled property and to remove
My
construction
lord, he
therein.
has
That
purchased
means
the
that is a
land.
mandatory injunction.
My lord, I am submitting. Purchased the land in 2001.
He
My
has
lord.
read A, he omitted to read B.
My lord, purchased in 2001, filed one writ application before this Honorable High Court. Honorable High Court action. Then, my lord,
Given you enough.
my lord, losses, can you
enough
place the evidence of the government?
Sir,
At least, my lord,
we will-
losses, allow me
sir,
to place the government
place
said
it.
it is not.
Sir,
It is the
sir, I
property
am
of.
saying, I am requesting you, beseeching you, place it.
My lord, losses, can
I am conscious of the judgment of the Supreme Court in case of the state of Maharashtra versus Ramdas Srinivas Nayak, AIR 1982 Supreme Court 1248, if I am not wrong. There, the apex court has said that if anything is recorded in the judgment, that recording would be treated as sacrosanct. Nobody can contradict by way of an affidavit or at the bar.
Well, losses, kindly come to
Only question, I am conscious of the substantial question of law, which says that if the finding appears to be perverse, then in that event, it is a good substantial question of law, good ground to interfere. If the court has said, both the courts, that the government officials were firm in their stand that the entire B scheduled property was acquired by initiating an acquisition proceedings.
My lord, losses will.
Now, question is, if there is any obstruction created in the B scheduled property, he is entitled. Where is the difficulty?
May I submit? May I submit, my lord? My lord, losses, kindly come to. We have said it is our land. We have produced our purchase. Everything is there, my lord. Purchase.
Does it mean the title? I am talking about it.
My lord. Losses, kindly come
Recording of a name in the record of right creates any title?
My losses, kindly come to page 6. Page 6 of the trial court judgment. May I read, my lord?
Yes, read it. We have given
The
you
defendant
enough
number 8.
time.
Defendant number is, my lord, the government officials, land department. That is, state of West Bengal has also denied and disputed and contested the plaintiff's claim in their written statement. According to defendant number 8, on page 6, my lord, of the trial court judgment. Inner page, my lord. Defendant number 8, the present LRROR published in the suit property 1020
by
with an
1028
area of 98 acre of the Haringata Mauja has been recorded in the name of Yar Ali Sheikh, Jair Ali Sheikh and Dalal Sheikh in respect of the Kotian number such and such, with area of 20, 20 and 33 decimal in the land respectively. According to them, the suit plot number 10201028 classified as a non-Julie are recorded in the name of Arjun Sheikh.
So can you claim title over B schedule property on the basis of the
Yes,
record of
Malad,
right?
it is in our name. It is not acquired. It is not acquired.
Does a record of right confer any title?
No, Malad, it is not acquired. It is they only acquired the road portion, not this portion. This is government submission, my lord. This is government, not my submission.
Sir, it is a
Who will say that it is acquired, my lord? Who will say acquired? Well, government will say acquired. Government said it is not acquired. Government said it is not acquired at all. And they may read, my lord. That recorded accordingly, the suit property 10201028 classified as non-Julie are recorded in the name of Arun Sheikh, Alamuddin Vishas. They are the my predecessors of my family member. These persons are also with legal heirs are possessing the said land, and it has not yet been recorded in the name of PWD. According to them, the allegation made by the plaintiff in the plaint has already been agitated by them before the Honorable High Court in read petition number such and such in the matter of Sirajuddin Sheikh, that is husband of the plaintiff, Malas, in whose name the state of West Bengal and others. It is further mentioned by them that the suit plot number 1020 has been recorded in favor of the Sirajuddin, that is husband of the plaintiff. And the present classification of the suit plot is house, and the claim of the plaintiff on the being the residential house over a scheduled property is a vague blunt lie and a mere creation of the made for the purpose of filing the instant suit. Under the above circumstances, the defendant number had paid for dismissal of the suit. That is the government submission that the suit plot belongs to the defendants. Yeah, with that name. That is B schedule property. So, we have said we are in possession. We are still in possession in B schedule property. Government said it is their property, not the A. And that is the regarding the engaging. If I have a land, and somebody says I will go through your land, there is a side road, there is a side road. He cannot show any purchased it from 2001 purchased it. That there is a injustice against from my land. They cannot show it, my lord. So they forcefully, the court, landed court below and the appeal court did not go through the, my lord, pair of the petitioner, plaintiff, and they passed judgment beyond that. And the appeal court has not recorded the submission of the PA court. That is my submission. Government recorded that it is my PA. That is one.
Thank you.
And there is no pair need not in respect of the ingestion case. The judgment beyond the pair matter. That is my submission.
That's all, sir.
Come. And I am grateful of Joseph Hardby for few minutes.
A right is sought to be claimed in respect of the property solely on the strength of the record of entry in the record of rights, belying the stand that the said property was a subject matter of acquisition proceeding initiated under Act 1 of 1989. It is a suit simpliciter for permanent injunction permanent injunction against the appellants from interfering with the possession in respect of properties described in Schedule A appended to the plate, and mandatory injunctions against the appellants to remove these obstructions caused to the A schedule property, and also to remove the constructions made upon the B schedule property. To stop. The case made out in the plaint proceeds on the basis that they inherited the schedule property described in Schedule A to the plaint from their predecessor in equal share.
Kindly,
No, sorry, কি বলেছি? No, they know. That their vendors করো। From their predecessor in equal share, and subsequently sold, transferred, and conveyed the same to the pro forma defendant, being the husband of the plaintiff respondent. It is further averred that the pro forma respondent, being in military service, was unable to look after the affairs of the subject of the A schedule property, and entrusted the wife to do the needful. To stop. It is further stated that the name of the predecessor in interest of the pro forma defendant is duly recorded in the LR record of rights. Finally published LR record of rights. And on divestition of their right, title, and interest, the pro forma defendant acquired an absolute right in respect of the right and title in respect of the A schedule property. It is indicated in the plaint that the B schedule property was a subject matter of an acquisition proceeding initiated way back in the year 1963, and there is an existence of Nyanjuli, which is a fish pond.
No, ditch.
Nyanjuli is within bracket ditch. Ditch by the side of road. Ditch karo, by the side of road. Creating an obstruction to the ingress and egress from the B schedule property to the A schedule property. It is sought to be contended. No, sorry, get it out. The defendant took a stand that the B schedule property belonged to them on the strength of the entry made in the record of rights, and on the strength that there was no acquisition proceeding ever initiated in respect thereof. The claim is also founded upon the law of succession as the they claim to have inherited the same from their predecessor. Since the next paragraph, since the entry in the record of right was also averred in the said suit, the government officials / the government departments were also made party. Both the courts found that the defendants have failed to establish their right, title, and interest in respect of a B schedule property, and proceeded to decree the suit in favor of the plaintiff, who is admittedly found to have right, title, and interest in respect of a scheduled property. The counsel for the appellant vociferously submits that both the courts have not taken into consideration the defense taken by the defendants, appellant, and therefore the judgments rendered by both the courts are liable to be interfered with. It is further submitted that the record of right stands in the name of the appellants, which is undeniable, which is undenied, and therefore it cannot be construed that the B schedule property was ever acquired by the government upon initiating the acquisition proceeding. Though feebly, it is sought to be contended that the government officials in fact admitted that the record of right stands in the name of the appellants, having right, title, and interest in respect of a B schedule property. And therefore, both the courts have wrongly held that the plaintiff respondent is entitled to a decree as prayed for. Next slide. There appears to be a fallacy in the submission advanced by the appellant before us. At the outset, we must recapitulate the proposition of law promulgated in respect of claiming a title on the strength of an entry made in the record of rights. It is no longer res integra that the entry made in the record of rights neither creates title nor extinguishes such title. The entry in the record of rights may have a presumptive value of possession, but the same is not sacrosanct and susceptible to be rebutted on the basis of the valid and cogent evidence. The entry made in the record of rights is only for the purpose of making a person liable to pay for a government revenue imposed upon a land, but have no bearing in creating any title into a person, which can only be created by taking recourse to the provisions contained under the Transfer of Property Act and the Registration Act. There is no document of title forthcoming from the possession of the defendant appellant, as they simply banged upon the entry made in the record of rights in support of their contention that they have,
it is an ancestral property.
whatever, they have acquired the right, title, and interest, which in our opinion cannot be a conclusive proof of title.
Exhibit 4 and Exhibit 9. Exhibit 9 is the position.
এখানে বলেছে সার্টিফিকেট অফ পজিশন উইথ এক্সিবিট 9 এটা না এটা আমি
সার্টিফিকেট অফ পজিশনটা কোনটা দেখে নাও। এখানে দেখো
exhibit a map along with certificate of position.
এই দেখো লেটার ইস্যুড ফ্রম দ্য অফিসার ফ্রম দ্য কপি অফ দি অরিজিনাল রেলরোড না
আমার মনে হচ্ছিল 6 and 6
copy. হ্যাঁ মনে হয় photocopy the certificate copy the land acquisition plan map certificate copy of the letter permission slip received
6 and 7 हो जाना report of PLR and copy of map certificate with 6 and 7
6 and 6A
6 and
6A
6 and 6 এটা ভাইটা ভুল
কি বলেছি
exhibit 4 exhibit 6 and
exhibit 6 4 6 and 6A would reveal that the proceeding was initiated for acquisition of the property described in Schedule B to the plate way back in the year 1963, which culminated into an order which culminated into a determination and payment of the compensation and position taken by the government. The aforesaid documents are sufficient enough to indicate that even if the record of right stands in the name of the defendant's appellant, but the same was a subject matter of acquisition, and therefore the findings of both the courts below in this regard cannot be said to be perverse and or based on no material. We are conscious that it is a suit simpliciter for permanent and mandatory injunction, and the question of title may be irrelevant. Yet, the defendant appellants have raised such issue of title, which appears to have us to have been incidentally involved in the said suit, and therefore such finding of the both the courts below cannot be perceived to have been made beyond the scope or the reliefs claimed in the plaint. Though it is sought to be contended that the government officials who were called as a witness corroborates the case of the defendant appellants, but we find from the concurrent finding returned by both the courts below that the government officials have corroborated the case made out by the plaintiff respondent that the B scheduled property was a subject matter of acquisition and in fact belonged to the government. So, mere wrong entry in the record of rights can never be perceived as a creation of a right. Stop. Furthermore, An application for correction of the record of right is also pending before the appropriate authority. And therefore, we do not intend to make any comment thereupon. It further appears that it has not. We do not find that there is any plea taken by the defendant appellants. That the access to the A schedule property is not through the B schedule property, and therefore we do not find any infirmity in the impugned judgment that a mandatory injunction was passed for removal of the obstructions and restoration of the free passage for ingress and egress to the A schedule property. The reliefs claimed in the plaint is to be read has to be read conjointly with the pleadings made therein. And there is no fetter on the part of the court in passing the mandatory injunctions, provided the pleadings and the evidence in support thereof has been led by the parties thereto. We therefore do not find any substance in the contention of the counsel for the appellant that there was no relief claimed in respect of a B schedule property, and therefore the court ought not to have granted a mandatory injunction. Semicolon. Rather, we find that there is a specific relief claimed in this regard, and therefore the contention does not appear to be correct. We thus do not find any involvement of the substantial question of law in the instant appeal. The same is hereby dismissed.
What is the defect, Dekhi? Is it court fee or the? Seen in the report of the staff reporter put on the reverse of the first page of the memorandum of appeal, indicating that the instant appeal is filed with a deficit court fee of rupees 167.50 paisa. So time to put in the deficit court fee is extended by 2 weeks from date. In default, the appeal shall stand dismissed. Fifteen, কি আছে দেখি?
16 mallet, I appear for the appellant mallet.
Just a minute, 15. 1-5.
হয়নি। এটা section 5 মনে হয় dismiss করেছে, সেই জন্য এটা করছি। Pass over করো।
16 mallet, I appear for the appellant mallet. Mallet pursuant to a lordship's direction, mallet.
What two applications?
Mallet application for injunction and mallet an application for no, right, that's the application for praying leave to present the memorandum of appeal against the years and
Service of, where is the affidavit of service? এটা নিশ্চয়ই কোনো একটা আছে যে এই স্টেজে ডিসপোজ অফ করে দেবো। Service code.
by the order impugned mallet section 5
I understand because the
My-
nature of the order is like that. So was the service refused.
mallet.
Only one respondent.
Only well,
There are many.
but the only
And others.
only mallet the one is the contesting respondents. Mallet there was direction was upon one only. Right.
Then what to be done, sir? The difficulty is if he does not appear, then the others. Who are the others?
But others mallet other heirs of the mother mallet. Mother initially filed the suit mallet for eviction of the respondent number 1 mallet. That suit was decreed mallet. Subsequently mallet regarding the declaration of the property that it is not the mother's property mallet.
Whatever. So what can be done? If they do not appear, then we have to admit the appeal. Nothing more. We wanted it can be disposed of, but section 5 ka first appellate court দিয়েছে। Problem এখন হয়ে গেছে না।
Even mallet the order was served also mallet.
That is-
Not a minute. Then our question of law claim forward comes.
He's not appearing. Refused. Is it what is the nature of the decree? Has it been put into execution?
No mallet, the decree is dismissal of the suit. mallet.
Suit. Oh, then otherwise I was thinking of service upon the advocate.
No mallet, nothing is pending.
The suit for eviction of a licensee.
Suit
That
for
suit
eviction
was dismissed.
dismissed mallet.
Learned first appellate court refused to condone the delay.
Refused to condone the delay and mallet I am a subsequent purchaser mallet. I have also filed an application mallet for preferring the appeal. That has also been turned down mallet. On the same date mallet. That is mallet order number 25 dated 20th of January 2023.
দেখো The appeal shall be heard on the following substantial question of law: whether the Court of Appeal below was justified in entering into the merit of the appeal at the stage of considering an application for condonation of delay filed under Section 5 of the Limitation Act. Next, whether the Court of Appeal below was justified, both the courts bolechi na Court of Appeal, whether the Court of Appeal below was justified in holding that the petitioner has not been able to make out a sufficient cause occasioning the delay in preferring the said appeal, and thereby taking a pedantic and the strict approach next, whether the Court of Appeal below was justified in arriving at the conclusion that an application under Section 5 of the Limitation Act is not maintainable when an appeal is filed under Section 96 of the Codice Procedure. Usual order for special messenger costs, deposit, requisites, deposit within a week from date. Paper book, 4 weeks from date.
But injunction application be status quo be maintained by
Before the service, before the regular bench. Dutoi.
That's 17 not pursuant to my lords. Dated 27th of February 2024, I have deposited my lord the deficit court fee amounting to rupees 7,760.
The counsel for the appellant submits that the deficit court fee has already been put in. Vide filing number, document number.
Kindly similar now CIS system, this is
Document number is there, 1 or 2 word at the bottom.
1.
Document number 1, dated
Not 28th of February 2024.
28th February 2024. Office is directed to tag the deficit court fee with the memorandum of appeal immediately. Now tell me what is first tell me who are you, plaintiff or a defendant?
I am the defendant number 1.
Defendant number 1.
Suit instituted under section 22 of the Hindu Succession Act.
Preferential right.
Preferential
right. Both the courts have held in your favor or against you?
Against.
They have permitted.
Kindly takes up the plaint once. The genealogical table is there. Plaint.
No, let us see. Just take your seat. Let us go through the order of the appellate court first.
হিন্দু লট এনে দেবেন।
আচ্ছা আচ্ছা এখানে দাও। আচ্ছা আচ্ছা Yes, sir.
The ground which has been taken, or rather the defense which have been taken by my client regarding the Borgadar ship, that is neither they are not.
You would remain as a Borgadar.
Yes,
It will not extinguish even a title of a riot is transferred.
Now what I am on, here, if your lordship takes pen, to come to the application once, may I show your lordship the plaint? Page 17 of my can. The person who has claimed the being the original plaintiff, being a class 1 heir of the mother, who was the owner of the property, he died.
So extinguishes.
During pendency of the suit.
Extinguishes.
Whether the substitution, the language of section 22 is it has to be exercised by one of the class 1 state.
Correct. What does it mean? He exercised.
Yes, but after the death.
After the death means?
After the death, prior to passing of the any decree.
So
extinguishes. In one of the view I have got. I have got in one of the judgment that says it extinguished.
No.
The right to substitution.
To us, I am not in agreement with that. Because the class 1 heirs asserted his right of a preferential right, and thereafter if he dies, that particular right does not extinguish because of one reason, that his sons and daughters are still regarded as a class 1 heir. Think a position. Class 1 heirs.
In respect to the property.
Oh, sir. I'm giving you a hypothetical example for this. Suppose the plaintiff died before the mother. Correct? Whether his sons will be regarded as a class 2 heirs. Son of a predeceased son, daughter of the predeceased daughter, they are all within the purview of the class 1 heirs. If they are within the purview of class 1 heirs, then the right to sue survives upon them because they can initiate. I have doubts. If you show me a judgment, I will make a dissenting view on that.
But that should be a substantial question of law then.
Cannot be. Show us the judgment.
But kindly see once the plaint. Once your lordship looks at the plaint once. But here, Shukeshi Maiti was the original.
Was the original owner, no doubt about it. The original plaintiff and the pro forma defendants number 2 to 5 were the heirs, no doubt. They sold the property to you, no doubt. You say that you were already a Bagadar in respect of an agricultural land. The court has said admittedly it is an agricultural land. You took a plea that you should go under section 8.
Yes, that defense
that is not available. If section 22 is not a any reservation, that it is only restricted to a dwelling house or a vastu land. It simply says the preferential rights. If the property is originally owned and they are the class 1 heirs. So it does not make any distinction. Even a Supreme Court in that Baburam judgment or Babulal judgment, what is that? Supreme Court has also said that it applies to agricultural land as well.
Section 20.
Baburam.
There is no distinction.
So that goes against you. Question is, you are a subsequent purchaser. You claim Bargadar. Remain a Bargadar. Your status is not destroyed.
Now, in the present case, the name of the plaintiff was also took place in the deed. So
whether he was a signatory?
No.
So you chose what to purchase. You chose.
Now, the Sukeshi, when died, Saroj, Taposh, Manos, Kuchorita, and Modhumita, the husband and the sons and daughters.
There is no doubt that the predecessor in interest of the substituted plaintiffs and the pro forma defendants are the legal heirs of deceased Sukeshi Maiti.
My lord.
Am I correct?
My lord.
And it is also admitted position that the main defender, the contesting defender, your client, who is the appellant before us, is a Borgadar.
But that has been claimed in the written statement.
Yes.
Yes.
So they are Borgada. So under section 22 of the
No, there is no preferential compartment otherwise created for Borgadar. It is under section 8 of the Land Reforms Act. The Borgadar given a preferential right,
and that right accrues when it has been transferred to a third party.
Third party.
But then here the case is otherwise. An interest over the immovable property belonging to the plaintiffs, substituted plaintiffs, the predecessor interest, and the pro forma defendants has been transferred in your favor, you being a Borgada. So it is the concurrent finding of the learned trial court as well as the first appellate court that the preferential right still exists in favor of the plaintiffs. So where is the wrong, sir?
The point which I can only able to canvass is regarding the right.
I am surprised from Purva Mednipur because the lawyer was conscious that if we go under section 8, I will be defeated.
Yes, but they are very, I must say. But in one of the matter,
very, very intelligent, I must say, very intelligently drafted.
In one of the matter I have got, after the Supreme Court judgment regarding the payment of entire consideration amount within 1 year, what happened? Parasat Eye Hospital. What happened? One of the learned advocate, very I must say, cleverly and very intelligently, he has filed the preemption case with the not
entire consideration.
No, not entire, but insufficient the consideration money as per his own whims. Immediately thereafter, what he has done, he has deposited the entirety within 1 year. The Supreme Court said it has to be the right
within the period of limitation.
So he has deposited and filed an application that was turned down. And thereafter, this went up to this honorable court. I argued that it has to be within the period to trigger out the right, and for a non-notified co-sharer, the right will trigger out up to 1 year. After that, the Supreme Court also affirmed this. So, one of the avenue was carved out that this is
Because
something
that was under Article 56 or 90,
Article 97.
97
Article
of the Limitation Act.
Limitation.
I have also held 1 year.
Yes, 1 year. And thereafter, our special bench also will not. But may I just show this judgment paragraph 12? Your Lordship consider this. This is my point I can canvass. But I must be candid before your Lordship. I have also thought that yes, section 15.
Punjab and Haryana, you have gone.
I have got
they have got a different the act.
Different Land Reforms Act, I believe.
No, this is under section 22 of the Hindu Succession Act.
Which paragraph is relevant?
Paragraph 12 onwards, but
that too a single bench decision. It's a single bench decision.
But
no,
I am not saying that for a moment it has a binding effect on your Lordship, but it may have some persuasive effect. Because I have found on this court, একটা copy আনিস
can't be a personal one, sir. It runs through the property. What are you talking about? I'm making a
It is
decision.
not a personal right.
Definitely not a personal right. Absolutely wrong proposition that has been given.
It is attached to the immovable property.
What are you saying? Running,
property.
it's a,
And Milord, I must say before your lordship, Milord, I have considered section 15A, section 15(1)A creates the trouble. If it is doesn't include, because section 15 says about, Milord, in case of a succession of a female Hindu. There, Milord, the language is the property of a female Hindu dying intestate shall devolve according to the rules set out under section 16. Now, A, firstly upon the son and daughters, including the children of predeceased son and daughter and the husband. So it's not a general schedule 1, schedule 2, but section 15 creates also a trouble. Because in that event, Milord, the predeceased son and daughter includes, Milord, the substituted heirs. But this judgment, Milord, gives them, Milord, because it's exactly the same situation.
No. There's a preferential right cannot be regarded as
So,
a
lordship, think, Milord, this should have been, Milord, considered in other lines.
It's a running through the land.
That's why, Milord, I say it can be a substantial question.
No.
To be decided, Milord.
No.
Let us venture on this issue, Milord, whether I can.
Cannot be. Conscience
Because your lordships know.
does not permit.
Your lordships have decided once that whether, Milord, after the transfer is being taken place in one of the matter, whether the section, and that view has been, Milord, now, Milord, it's settled. Now it's settled.
I have held that even a transfer is affected.
Milord, I have
Section 22.
because I tried to venture on that issue also in this matter. But
proposes to transfer means the transfer has not taken effect, but in the process of being transferred.
that's say you have to interpret. Yes.
I held no. Even a transfer is affected, that can be the ground.
So, Milord, thinking on that angle, if this can be, Milord, argued in future, I leave it to your lordship.
Argue in future, here in presenti, argue in presenti, straight away.
I could able to gather, Milord, this point. Event of chart.
Yes. The seminal point urged in the instant appeal at the time of admission is that upon the death of the original plaintiff, who was admittedly a class 1 heirs within the purview of section 22 of the Hindu Succession Act 1956, comma, her heirs and legal representatives cannot carry forward her claim as the right of preference, as the preferential right envisaged under section 22 of the said act is personal one. The support is lent to a single bench judgment of the Punjab and Haryana High Court in case of Kamal Goel versus Purushottam Das, reported in AIR 1999, Punjab and Haryana, page 254, wherein it is held that the right the right postulated under section 24 of the said act being personal one, and therefore 22 have 22 24 bolechi 22 have, and therefore the right to sue does not survive upon the heirs. Upon the date of the original, would bole dijiye. A prelude to the litigation is required to be recapitulated and adumbrated before embarking upon the core issue as indicated here in above. Admittedly, the property belonged to Sukesi Maiti, and upon her death, it devolved upon her sons and daughters,
including husband.
And the husband. The word under section 15 is and husband. In accordance with section 15 of the said act. Apart from the original plaintiff, all other successors of the Sukesi Maiti sold, transferred, and conveyed their share in favor of the appellant. And upon coming to know of the factum of divestition of right, title, and interest by the aforesaid successors, the suit came to be filed at the behest of one of the co-sharer / co-owner, being the original plaintiff, before the civil court. Next paragraph. The plea is sought to be taken by the contesting appellant that they are a Bogadar in respect of the larger property, and therefore acquisition of right, title, and interest of his superior cannot be regarded as
a right restricted under section 22 of the said act. Full stop. It was also it was also sought to be contended that the property being an agricultural land, comma, the preemption is maintainable under section 8 of the West Bengal Land Reforms Act 1955 and not under section 22 of the Hindu Succession Act 1956. On the on the prospectus of the aforesaid facts emerged from the respective pleadings, comma, the parties adduced evidence, and both the courts below concurrently held that the right of preferential, that the preferential right under section 22 of the Act is unaltered and cannot be defeated on such score. Stop. Now, indubitably, while next paragraph, indubitably, during the pendency of the suit, comma, the original plaintiff died, and the sons and the daughters were duly substituted in the said suit and continued to sorry, the widow, sons and daughter were substituted and continued with the said suit. The point, as indicated in the opening paragraph of this judgment, does not appear to have been taken before the court of original jurisdiction as well as the appellate court, but as a point of law based upon the facts emerged from the record, comma, such plea has been taken before us. It is not in the only before we delve upon the aforesaid issue, we feel it prudent to consider the right conferred under section 22 of the said Act in the manner sought to be agitated before us by the counsel for the appellant. It would be profitable to quote section 22 of the Hindu Succession Act 1956, which runs thus, quote, it is manifest from the bare reading of the language used in the aforesaid provision that a right is conferred upon a class 1 heir to claim a preference in the event an interest in the immovable property or a business carried on by the deceased dying intestate it is manifest from it's proposed to be transferred to a third party The question is still begging an answer whether the interest in the immune property of an intestate would be regarded as a personal right, or such interest does not run through the immune property, capable of being devolved upon the heirs and successors by virtue of the provisions contained in the said act. In other words, whether the interest can be perceived as a personal interest, or the interest running with the land, capable of being devolved upon the successors under the law of succession. The phrase interest in any immutable property within court has to be construed as an interest akin to a right and the title conferred upon the successors, who would still be regarded as the owner of the property by virtue of a devolution under the said act. The owner of the property enjoys multiple rights, including the right to alienate, transfer, encumber, which in no way to be imagined that being personal, such interest or the right shall not pass to the successors. The devolution of an interest of the predecessor in respect of her / his state connotes the passing of such interests amongst the heirs / legal representatives / successors recognized under the said act. Precisely for such reasons, the successors / heirs are regarded to have stepped into the shoes of their predecessor and are bound by any act or the things done during his lifetime, and cannot take not take any defense, dehorse the act and the thing done by the predecessor, nor can elevate their status above the status of their predecessor. The aforesaid principles is well founded on the legal maxim within court, nemo dat, code non habet, meaning thereby a person cannot give what he does not have. taking a pedantic view that the interests in respect of our immovable property is a personal interest of such class 1 heir would offend the legislative intention underlying the incorporation of the provisions relatable to a preferential right. The matter can also be viewed from another angle. The word class 1 heir has to be understood in a broader and pragmatic manner, and it is inconceivable that in the event of the death of the original plaintiff before the institution of the suit, the substituted heirs are recognized as the class 1 heirs, and therefore we do not find any incongruity that even after the death of the original plaintiff during the pendency of the suit, they would lose the status of a class 1 heir. To stop. It is no doubt true that so long the original plaintiff remained alive, the right upon the substituted plaintiff does not come into play. But the moment, but on the death of the original plaintiff, the right or the interest which runs through the land can be pursued by his successors and heirs as they stepped into the shoes of a class 1 heirs and pursuing the claim which runs through the land and cannot be regarded as personal. Stop. The personal right, as known in the legal parlance, is such right which is attached to a person and does not pass on to his heirs as it perishes on his death. The law of tort can also be considered in this regard as a personal right which is incapable of being passed on to the heirs, provided such wrong does not run through the land or something which is otherwise recognized in law. We are unable to comprehend the notion of personal right under Section 22 of the said Act as held by the Punjab and single bench of the Punjab and Haryana High Court, as we find that the learned single judge omitted to take into consideration that what is passed on under the aforesaid provisions is the interest in any immovable property which is capable of being inherited by virtue of a law of succession. And therefore, we are succession, full stop. We cannot comprehend. Stop. any other interpretation would run counter to the legislative ethos and would undermine the law of succession enacted in this regard. Full stop. We thus do not find that there is any involvement of a substantial question of law in the instant appeal. The appeal is dismissed under Order 41, Rule 11 of the
But
court.
my right with regard to Bargadarship, that is not being dealt with.
Why we will disclose?
Kindly mention that portion.
I have first paragraph. I say only point you have agitated.
That is I have urged also.
You know it very well. This is not a correct proposition.
But sometimes we have very trouble to find out.
If it is something of substantial nature, yes, we'll take up after 2.
18, it has been stated that wrongly listed.
19 I for the appellant.
Wrongly listed.
Number 18, my lord, I appeared on behalf of the respondents.
Is
my lord.
wrongly
19, 19.
What I tell you, lordship, my lord,
Send it
19,
for
18.
orders next week.
next week. Kindly fix a date, my lord.
Already there. Next week you will find 4 orders will take up. Yes, 19.
I'm great.
19? 18?
Item number 19 was ours.
Yours is 18.
19. We have for the 19.
টা কি করলে? কেউ নেই তো দেখাও ফাইলটা।
আপনি 18 কেন বলছেন? আমরা 19।
এটা অনেকদিন থেকে অ্যাপিয়ার করছে, নতুন, তবে ঠিক আছে, যাও। ফার্স্ট টাইম 20
That's suit for passing off. Right?
For the respondents in this matter, your lordship.
There is no
I appear for the respondent in the matter, your lordship.
injunction.
But
Refuse.
injunction refused by saying that I have a good prima facie case and everything is in my favor. He says it's a good case for injunction.
Then why dismiss?
But please come to
No, it
page,
is allowed.
my lord,
Allowed in part.
in part, in part, in part.
So
I'll just give your lordship the facts before your lordship goes into the judgment.
Rista.
Yes, Rista is the trademark. Now, my lord, I applied for an injunction. My lord, I deal in various types of food grains, vegetable oils, and other things. I have been using this trademark from 2005. Sorry, 2000, from 2000. Now, my lord, I also have registrations, but that's not relevant over here. Now, my lord, my learned friend is not selling rice under the name Rista. I filed a suit. But again, same name. Lord,
Rista.
yes. And your lordship will find he
Not
gives his,
Rista. That's why I.
yes, and he gave himself
Selling what?
rice.
Right.
Rice. Now, my lord, he gives himself the corporate name of New Rista.
New Rista.
New Rista, that your lordship will find from the cause title. So, my lord, I
That means a relation.
relation. So he wants to have a relationship with me, obviously, which is
No, he
not
wanted to create
acceptable.
a new one also.
Not acceptable, of course.
Not even a new one.
Looks like not. Certain things are, well, one gets used to the old relationship. I'm sure head office doesn't permit various types of new relationships also.
Okay.
So now, my lord, we applied for injunction. Now he files a bare affidavit in opposition saying that he has allegedly been using this from the year 1995. Not one document annexed.
Defense under section 34.
Not one document annexed, nothing. One bare
Section
statement.
34 defense.
Lord, also that.
Also that.
He claims, Lord, that a predecessor of his allegedly has been using it from 95. Now, not a single scrap of document is there, Lord. It's a tall tale. Not, there would have been some evidence.
Never applied
On
for
the
also.
contrary,
Never applied for also.
he did. On the contrary, he applied to the trademark authorities in 2017, claiming user from 2006, which is after mine. So, my lord, this story of 1995, my lord, has to be completely disregarded. There was no material on the basis of which the learned judge could have held that he is the prior user for rice. He has gone on that basis that, look, he may be a prior user for rice. So, therefore, no injunction as far as rice is concerned. Now, there too, the order is not very clear. If your lordship, my lord, comes to the
It is only
last
says
page.
that in respect of a edible oil,
Yes, yes.
not rice.
No, I have no registration
But-
for rice. Which is why I said not passing off. I'll concentrate on passing off only.
I understand.
Yes.
The injunction is restricted only to a edible vegetable oil.
My lord, would your lordship see the just
I'm
before the
looking at page 10, the
Yes, ma'am.
operative portion
yes,
of the order.
just come back to page 9. Arey Baba, yes, yes.
It says restrained from ad interim order from using the trademark Rista
My lord, if your lordship would
along with
just
the
come to,
design
please come to page 9.
only in respect of a edible oil.
Yes, my lord, please come back
You
to 9.
wanted that rice should also
Yes,
be there.
yes.
I understand.
Yes.
I am coming that. That's why I say,
Yes.
let me have a clarity of that.
No, what I'm saying
For
is
that
there is no-
reason you have come.
yes, yes,
That
yes.
why it should be restricted to edible oil, it should also be on a rice.
rice and all other, not
Allied.
everything, I make atta, not gehu, all of that. Now, if your lordship just comes by one sentence, I'll show your lordship from page 9. There's some confusion of thinking. But I'll show the rest of the order later. But just before the ordering portion, not the second last para, hence in view of such, it would not be prudent to pass any blanket order of preventing injunction in respect of other articles apart from rice and edible oil.
Then he includes.
He is included. Oh, no. Now, as far as his two other paras I just show your lordship. Please come to page 8. I'm sorry.
Yes.
Two other portions I just show your lordship. Please turns to page 8 of the order.
Yes.
Last para. I find that there is bona fide contention of the plaintiff as regard likelihood of causing confusion among customers and loss of business of the defendants are permitted to use the registered trademark Rishta along with the design as stated in the certificate in respect of edible oil for their personal gain. So, my lord, he finds there will be confusion for that. Now, my lord, considering, next page, my lord, considering the demand of the situation and urgency of the matter, I feel that the plaintiffs immediately needs a cool whiff of preventive injunctive order for the purpose of protection of further damage of their trade and goodwill of their business, which cannot be adequately remedied by money value. Otherwise, plaintiffs are made to wait, then plaintiff would have faced disastrous consequences. On the contrary, it would be tantamount to permitting defendants to represent his goods or merchandise as goods of the plaintiff by using mark symbol which is registered in favor of the plaintiff, number 1. Therefore, I am convinced that the plaintiff is under peril and exposure to harm, and they have proved prima facie case in respect of the registered trademark along with the design, etc., in respect of edible vegetable oil and prior user. So he finds prior user also. But now, please see this is the part which not. But on the other hand, defendant has prima facie, now mark the word established his right over the trademark Rishta for rice products under class 30 since 2nd of July 2012. And please marks this prior user from 2nd October 2006. Look at the contradiction.
After registration. Huh?
Look at the contradiction. I am prior user in 2000. He is prior user from 2006. Now, admittedly, application of both the parties in respect of various articles apart from rice and edible oil are pending. Moreover, contention of the parties as regards use of the mark since 1995 or from 2000 can only be proved by cogent evidence. Now, I have annexed a huge number of documents. He has produced not one. I'll show your lordship the written objection. So, on this basis, he says there will be, however, your lordship has seen the second last para. However, in view of such, it would not be prudent to pass any blanket preventive order in respect of other articles apart from rice and edible oils. Now, this makes no sense at all. Now, for this, if your lordship would only take a few pages, after that I won't trouble your lordship. Please take page 163, which is the written objection.
Last word, third line of the first paragraph of page number 9 of the impugn order. Kindly read.
Yes, madam. Hence, in view of such.
No, hence plaintiff cannot say.
Page number
9.
Yes, madam.
Last word, third paragraph, 1, 2, 3, 4, 5, 6. 6 lines.
Yes, hence plaintiff cannot say its registered trademark is infringed only on the ground of registration of the trademark when defendant is also enjoying registration of the trademark. Such registration also gives right to the defendant to use the same as provided in 28(1).
So, trial court has come to a prima facie finding.
Yes.
That you possess trademark in respect of rice only,
no,
whereas the defendant
is
vegetable
oil. Vegetable oil. Edible oil.
Yes.
Whereas the defendant enjoyed the registration of the trademark in respect of the rice and other food items.
Yes, madam. Yes, madam. But there the law is very clear. Passing off whoever is the prior user, not the registration does not matter. The prior user prevails over
That is section 34 is an exception.
My lord.
Section 34 is an exception.
Yes. Yes.
Which says that even if you are a registered trademark holder, if somebody is using prior to the same, then no preventive injunction. At least this much.
No, that will be not 27, 28, 29. I'll show your lordship. No, there the class also of goods will not matter.
Yes.
Not before I just go to that. Just one more thing I'll show your lordship. Not if your lordship.
What I was looking at the
Yes.
saving of the vested right.
Yes.
And it starts with a non-obstante clause.
Yes. Yes.
It says nothing in this act shall entitle
Yes,
the proprietor or a registered user of a trademark, that is you,
yes,
to interfere with or restrain, that is what is a use.
Yes,
the use of any person of a trademark, identical with or nearly resembling it to, in relation to a goods or services, in relation to which that person or predecessor of title has a continuously used the trademark from the date
Right.
prior.
Correct.
That is what it says.
Correct.
So that is an exception to the other rules or the provisions.
No, that will
Yeah.
apply not to an action for infringement. That rule will not apply for
To a passing off. I understand. That is what I'm saying.
Yes. Yes.
It will not apply to a passing off.
Yes.
It will only apply to a infringement.
My lord. My lord.
I know. I am conscious.
My lord. I know. Now, my lord, I'll just come to the legal part in just one more minute, my lord. If your lordship only sees just one other document. After that, I won't trouble your lordship on facts, my lord. Please take his written objection, which is at page 162.
I for the respondent, your lordship.
বলেছে তো অঞ্জলি but please turns to page 162.
Served upon us, your lordship. It's a contested matter.
There is no caveat. There is
I
no
understand,
caveat.
but this is not a matter, your lordship, where they have actually, your lordship, no expertly
but,
identifying order of injunction was there.
My learned
It's a
friend has
final-
no right of
final
audience
hearing.
at this stage.
I understand, your lordship, but if he serves a copy, your lordship, then the matter can be disposed of.
Admitting it. You serve the copy and then what we propose is that we do not want to delay it. We do not want to delay it. We want to fix this matter next week.
Yes, yes.
All the materials are already on record, and I think it can be disposed of
Yes, yes.
without any.
But there is a order 41, rule 27, annexing not one or two documents, not nothing much. But it's a
Are you serious on that order 41 rule 27? If you are serious, then we have to give them an opportunity to file affidavits.
but your lordship can take up the matter.
Yes, the appeal is admitted. The appellant is directed to serve the copy of this application upon the respondents. Stop. The respondents are represented before us and submits that the copy of the application may be served upon him. Stop. The counsel for the respondent also waives the service of notice of appeal. Stop. Do you have the spare copy?
Ajay, copy. But with Mr. Sengupta, no problem. It can be handed over.
The copy of the application is handed over to the counsel for the respondent in court today.
Okay.
Since the instant appeal arises from an order by which the interim order of injunction is granted in a limited sphere, comma, the interim bolo is a contested one.
Yes, yes, yes.
Yes,
Final
yes.
disposal.
Oh,
Final
temporary
disposal.
injunction, not ad interim order. Temporary injunction is granted. Temporary injunction granted.
Yes, 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 yes.
Because in a limited sphere, which according to the plaintiff appellant should happen. Granted in respect of the goods claimed by the respondents. That is the rise. Stop. Since the scope of the appeal is limited, we dispense with the formalities relating to the relating to the appeal being made ready for hearing. Stop. All the necessary documents relied upon by the respective parties are included in an application for stay. Included?
Yes, yes, yes.
In the application for stay filed in connection with the instant appeal. And therefore, there is no necessity of filing the paper book. In such view of the matter, let this appeal and applications be listed. Next week is, can we fix it on 20th?
Yes.
No, find out. Otherwise, somebody may go somewhere else. We don't know.
No, 20th is all right. 20 is good.
2-0. Under the heading Order 41 Rule 11. No, sorry. Under the heading for orders.
Obliged.
One indulgence, Your Lordship, before the next date, Your Lordship may be permitted to file the wakalatnama. Your Lordship.
File a wakalatnama.
Right now, Your Lordship, not.
Go and file it.
Your Lordship's pleasure to fix a time. Your Lordship's pleasure to fix a time. I have applied 6 o'clock time.
Yes, at 4:15.
Good one, you asked for it.
It's calm. It is for orders. In the morning, it will be taken up. Yes.
Yes,
Call the next.
I would have preferred the 4:15.
And after the respond number 2, 3, 6, and 7.
My lord, I am for the plaintiff appellant.
It is against the refusal of an identity.
Where is the plaint?
Plaint, my lord. Plaint is not annexed, my lord.
Where is the plaint?
Yes,
Give
yes.
us. Who's the advocate in record? Don't you know that what are the procedures to be given? What are the things which are required to be disclosed in the memorandum of appeal? Sorry does not make you alive of those facts. What should be the form of the memorandum of appeal? Are you aware? Are you aware of the provision?
I am praying leave, my lord.
Why? You have not given a valuation statement. Why you will not put the valuation statement? In order to ascertain whether the appeal would lie to the High Court or it will go to the District Court?
Well, it will lie, my lord, to be for the High Court, my lord, to be.
No, I know, I have seen, it's a more than 30 lakhs, I know. But why you will not put it? The stamp reporter is in fix. He is not in a position to give a report.
Kindly grant leave, my.
Leave is granted to the advocate and record to put in the valuation statement in the memorandum of appeal. Here and now. From where you got it that in the matter of an appeal against the impugned order, is this a way to draft a memorandum like an application? How long you are practicing?
7 years. 7 years.
7 years. By this time, one should. What is the matter about?
My matter is, my lord, regarding, my lord, partition, my lord. The plaintiff is the co-sharer of the joint property.
Ad interim order is refused.
Refused, my lord.
What is the nature of the ad interim order?
Ad interim order, my lord. The nature of the interim order.
Have you annexed your injunction application?
My lord. Yes, yes.
Huh?
Paragraph page 30,
Page 38.
38.
No, that is a prayer.
Prayer. Prayer is also clumsy.
To pass an ad interim, mandatory, temporary, everything. From making
What
partition
is that?
and
My lord,
plotting the undivided property.
My lord, they are, my lord, plotting their lands to the exclusion of the
What is your prayer, sir, before the learned trial court?
Trial court is that,
What is
my
your
lord,
prayer?
prayer,
At least at the ad interim stage.
Ad interim stage, my lord, what has happened, my lord, they earlier admitted my possession and accordingly this case has been signed by the defendants. But later on, what they have said that no, you are not entitled to any share of the property. They are making partition amongst themselves and making construction on the lot of land.
Sir, you are a plaintiff in the suit for partition?
My lord.
I believe so. It's a suit for partition.
Partition.
My lord.
So you are claiming a right title and interest in
I am in
the
possession.
share.
I am in possession. They are now, my lord, denying my possession. They even have recorded their names, my lord, in the record of rights, my lord. And I have even objection to that effect. To my exclusion.
How you have claimed the right title and interest in the property? And
My
this
lord,
is the
my
way you have asked
grandfather.
for an injunction not to making any partition. What are you talking about? That is your suit for partition.
Yes, my lord.
So,
my
what right you have pleaded?
Not to interfere with my peaceful.
This is what the injunction has been
sought. Such prayer is there.
You have sought for from making partition, first plotting the aforesaid undivided joint property
to the
by constructing respective pakka boundary walls in any portion of the property.
Well,
you have not said about your
exclusion of the petitioner, my lord. That word, my lord, is not written, my lord.
You have not claimed any position that your position should not be disturbed, your position should not be interfered, nothing of that kind you have played.
सर यहाँ पे है
number 23.
Yes. Kindly, my lord, see the police report, if your lordship kindly, with regard to possession, my lord. And also 59, my lord.
Sir, you have not claimed any relief in relation to possession, sir. You have not claimed, not a single whisper I could get it.
In the pleadings, my lord, there are.
No, sir. Then the question of temporary injunction application does not arise. You file a plaint and move the plaint and then say grant the temporary injunction application.
In the prayer, my lord,
Language in Order 39 Rules 1 and 2 says that on an application.
And also, my lord, court, my lord, can pass under section 151 of the.
Without anything before it.
In the prayer, my lord, to the exclusion of the petition.
On a verbal prayer, will grant an injunction.
One word, my lord, 2 words, my lord, has not been put in the prayer portion
Sir,
to the exclusion of the petitioner.
No, even then, then it does not relate to possession. It does not relate to possession. Even if we treat that word to be there, does not relate to possession. You are arguing on possession.
My lord, admittedly, I am, my lord, the co-sharer, and I mean.
Where is an admission that you are a co-sharer?
My lord, kindly see
paragraph. It is an admitted.
Page 59.
You use the word admitted.
Page 59, man.
Show us.
The case map, page 59. My lord, plot F, Shubhajit Roy. My lord, the defendant signed on the case map. My lord, kindly see, my lord.
This cannot be said to be an admitted fact. It is undisputed fact. You can say that there is no dispute.
Undisputed fact, yes.
Admitted fact.
No, undisputed fact.
So,
I'm sorry.
So now we don't know the sanctity, who has signed it.
Defendants.
These are the signatures of the defendants. Have they done it? Have they not done it? They have not come before the court as of now. Unless they disclose their stand on the basis of this document, then what the court is supposed to do? Tell us. And secondly, if there is already a by virtue of a verbal partition, it has been partitioned, then why you have gone for a suit for partition? It is already a partition property.
Forcible partition, not, my lord, amicable partition.
What is this? Is it not a partition?
In this partition, my name is there, my lord, in plot F.
I am asking, sir, is it not a partition?
Amicable partition.
It's a partition.
Amicable.
Amicable?
Yes, my lord.
So why you went for a further partition?
But my lord, my plot is, my lord, here, my lord. Plot F. Now what they are doing that, my lord, they are, my lord, to my exclusion, my lord, forcibly, my lord, has been disposing.
I understand, sir. Then why you are filing a suit for partition again? If the joint property has already been partitioned, according to you, can there be a double partition? I'm asking this.
Now they have partitioned amongst themselves, excluding me. They are forcibly, my lord, have.
So what is the remedy? If they have defied this partition, amicable partition, then what?
My lord, they are forcibly, my lord, interfering my position.
Sir, we are not an advisory. You have an advisory jurisdiction. You are the best person to advise. I am asking very simple question. If your stand is that you have already, that there was an amicable partition of the joint property.
But subsequently they refused. There are another case map, kindly, my lord, page 91.
Then first answer.
My lord.
which we expect is that why you have gone there to file a partition suit again.
My lord, page 62, kindly.
I do not know.
Page 62, my lord, kindly, my lord. Page 62.
You have approached
Subsequently, they have partitioned their
opposition
amongst themselves.
without making any whisper.
Sir, then again I am saying the advisory jurisdiction I cannot. You have a different remedy.
My lord, this court has, my lord.
It's a different remedy. Yes. You are for the respondents.
My lord, 2, 3, 6, and 7. Lord, they are virtually challenging the erroneous record of right. That, my lord, civil court doesn't have jurisdiction to correct the record of rights, my lord. My lord, kindly see the order, impute order in person, my lord. And the preference application to the LRO for the same purpose.
Sir, the court will go by the release claimed
I
in
have
the
not
plaint.
received, my lord, the plaint.
You will not receive. That's why, that's the wrong. You will not receive.
Not yet been served, not even annexed.
Correct. They have simply said that first thing is that the deed of gift which was executed by the defendant number 7 in favor of the defendant number 1 be declared as void first. Yes. Second is the declaration that they have 1/8 share in the property. Third is preliminary decree to be passed and then final decree dividing the property. This is a simple suit for declaration and partition. Nothing.
Let direct them to
It's
the
a
copy of
simple
the plaint.
So far, we have understood that after an amicable partition, it is the grievance of the plaintiff that violating the understanding, he is making an attempt to sell out those plot of land which belong to him. Is it your case?
Yes, my lord.
So far,
And
that case not have been made out in the plaint. I don't know.
Sir, it is still regarded once you defy the amicable, the partition, then it will be regarded as a joint property. If it is regarded as a joint property, the first and foremost thing is that he has to establish that he is a co-sharer or co-owner of the property. That appears that he is a co-sharer or co-owner of the property from the plaint. Then how you can proceed and change the nature and character of the suit property?
No, I am not changing nature and character of the suit property.
So we are injuncting you not to change the nature and character of the suit. Means not by dividing plots wise or something, nothing of that kind. No boundary wall, nothing should be. Should be.
My lord, situation is, my lord, they are challenging
Sorry.
My lord, they are challenging, my lord, what they are referring the partition. This is not at all partition, my lord.
So,
what they are challenging, my lord?
No.
Challenging my record of rights, erroneous record of rights.
No, this is not here. This is.
Kindly see the order in court, sir.
Sir, that is the wrong approach of the court. That is the wrong approach of the court.
Page 20,
it is a simple. It is a simple case. It is a simple case that on the basis of whatever the erroneous record of rights, you are claiming that you have become a owner. I am a co-sharer. This is what is there. To that extent, the court can. To that extent, the court can declare.
But there
is no difficulty.
Case,
even if the record of right stands somewhere else, but the court, if it finds that he has a title in the property, the court can declare it. It is not the authority who will pass a declaratory decree.
But there must be the prima facie case, my lord. There is no prima facie case for the set out, my lord.
Yes, let them show. They are claiming that how they have become the owner, how they have become a co-sharer. Show us.
My lord, my grandfather.
It will not. It will be served. Don't worry.
My grandfather, my lord, was the owner of this property.
Correct.
And after the death of
what is his name?
Sudhir Kumar Roy.
Sudhir Kumar
Roy.
Roy was the owner.
My lord.
Then he died intestate.
My lord, intestate.
Intestate. Then how many sons and daughters?
Sudhir Kumar Roy died, my lord, on 11/12/2003. Yes.
He on 4th of December, October 2001.
Yes, ma'am. Yes, ma'am. Gautam Rai, my lord, Vishwanath Rai, Bablu Rai, 3 sons. Josna Rai, wife, my lord, daughter, 3 daughters, 4 daughters. Rita Rai,
Gautam Roy, Vishwanath Roy, and Bablu
Bablu
Kumar Roy, they were the
Sons.
all sons. Sondha Rai
Rita Rai,
was the wife, that is, Sondha Rai is the daughter, Champa Das is the daughter, and Ruby Korvakar is the daughter.
my lord. Rita Rai, mother of the appellant, is the daughter.
Yes, Josna Rai was the appellant.
Wife.
The wife, sorry, widow. So in total 7.
My lord.
In total 7 years.
7.
Then,
my lord, my mother died. After the death of my mother, my lord, I am only son.
So in paragraph 2 and paragraph 3 of the injunction application, you have stated as to how you became the co-owner and co-possessor of the suit property.
My lord.
It is we the lawyer or you the lawyer?
Gautam Roy also died due to the pendency of the suit below. Suit was filed on 17th July
Have you
2023.
have you filed your written objection before the learned trial court as against the injunction application?
who has died? Gautam Roy.
Yes, Gautam Roy died.
But
29th
who
July
has not been
2023.
instructed, my lord.
29th July 2023.
Oh, then we shall file substitution.
Now we are saying
My
that
lord, we do not
living
know
in the
my
same property, co-owners, they do not know when the Gautam Roy died. But it
Suit
is the
was
privacy.
filed when?
Suit was filed on 17th July 2023.
And after the
After
suit
the
is
die.
filed.
Gautam Roy died prior to the institution of the suit or after?
17th July suit instituted.
When?
29th July died.
29/7?
2023.
Suit is instituted. Suit is instituted on
17th July 2023.
17th July. 12 दिन. Take out an application.
Well, let the
Take out an application. It
Mal-
appears that the respondent number 1
Mal-
is no longer in this world, but have been arraigned as a party in the instant. In the instant appeal. The counsel for the appellant is directed to take an appropriate steps.
a copy of the plate to be served to me. No writ of summons have been received, not yet.
Give him a copy of the plate.
In the meantime, my lord, status quo.
First regularize the appeal.
Yes. Sorry, man. I am sorry.
Any order against a dead person?
Yes, that person.
Call the next.
Madam, for the appellant, pursuant to my lord's direction on the last day, this pertains to a defamatory video that was published on our social media platform. My lord was pleased to direct us to file a transcript of the video. My lord, we've taken out the transcript. May I file the transcript? Very shortly, if I may indicate, my lord, this matter pertains to a defamatory video published by a disgruntled ex-employee. I terminate her from my services. She does not raise any allegations against me. Subsequently, after almost a month, she publishes a video on a social media platform. The notices were sent to her to take down that video. She does not take it down. There was a financial claim of the company. That money was also demanded from her. That is not paid. Ultimately, we filed the suit before the trial court. We moved an application seeking an ad interim order of injunction. It has been refused on other grounds other than the grounds made out in the injunction application. That will be apparent from the order impugned itself. And in fact, on the last occasion, your lordship was also pleased to ask me to point out.
KRA stands for?
I'm so sorry.
KRA. Our job KRAs are defined. Page 3.
Page 3.
Page 3 of your supplement.
What's the pay?
Yeah. Knowledge resource.
वो जानबे ना ये वो जानबे.
Knowledge resource associate or something like that. This is too much of a technical. In fact, on the last date, your lordship was also raised a query as to show from the plaint the imputations from the plaint as to how they are harming my reputation. But may I indicate them from my plaint itself? When my plaint starts at page 107, which is annexure M of your lordship's brief. Your lordships kindly come to paragraph 42.
Page 42.
107. The plaint starts from there. Now, paragraphs 42, 43, 47, 48, 49, 50, and 51 are the imputations. May I read it out for your lordship's convenience?
Page 107 is the first
Plaint.
page of the plaint.
Plaint,
And where is the which part?
Paragraph 42 I'm relying on, which is at page 153 of my lord's brief.
Yes.
Oh, she's still showing that she's employed with you in the.
So I'm sorry, my lord. I'm on page 123. I'm so sorry. 123. I went on a different paragraph. I'm sorry.
Paragraph 42, you said.
No, paragraph 42 at page 123.
I'm reading. She's simply saying that in the LinkedIn profile, she's still shown as the senior executive administration at you.
No, my lord, kindly comes to page 123, which is internal page 17, paragraph 42.
Yes, we are on that.
On that, sir.
But it continues, my lord. It starts from there. It continues on paragraph.
First, you have said that in the Facebook live,
yes,
they're saying considerable damage. And then say in the LinkedIn profile, she's still showing as an employee of your company. That cannot tantamount to, that may be the wrongly she's claiming.
No, no, there are other imputations also. Mara has to read the transcript for that. But she claimed she was sexually harassed by the management on a Facebook live video. Video page টা বলতো there is a screenshot of the video which is appearing at page 80. Your lordship will see the number of comments
Any order of injunction? No.
No injunction, Lordship.
Proceed with the suit. Remand. Proceed. He is asking for a time. Better you proceed. Yes. You want how much? 15 days time?
No, my lord. A week will be enough, my lord. Due to some emergency. He was in the morning here.
Whatever. No. Anyhow.
The
Not
learned
this week.
appellate court passed order for remanding and
Remand, I have seen that so that the suit will continue. Proceed with the suit.
yes, Lordship.
Yes.
According to your Lordship. Grateful, Lordship. The order may be reflected in the trial court not proceeded.
No, you go and convince. There is no admission of the appeal as of now.
Lordship, I know, but the learned trial
No,
court not proceeded.
nothing.
Pendency of these appeals.
Sorry. Show him the law. Yes, call the next.
My lord, plenty appellant before your lordship. My lord, there is some delay, my lord, in preparing the appeal, my lord. There is an caveat, my lord. We have served.
Why it is indicated as a defective?
My lord, defective, my lord. The section 5 application has been filed later on, my lord.
Have you served the copy?
My lord, served.
Received. Caveat is lost.
My lord. Application, both application as well as my lord, memo of the appeal. Served.
Anybody appearing? You are for the respondent? Yes, he's appearing.
My lord.
But
Can
where is the application?
Can application 2, my lord, section 5 application, my lord. There is some delay, my lord.
92 days delay.
92 days delay, my lord. I have explained, my lord, the cause, my lord. My lord, paragraph 5, my lord, misappeal filed, my lord, before the wrong forum, my lord.
Copy has been served.
Paragraph 5, paragraph 5 and paragraph.
Copy has been served.
Yes.
Yes, no difficulty. We are disposing of section 5. You know the view. Section 14 is entitled to take advantage of it.
But only I'm submitting that there was a first certificate copy.
What?
But initially, there was first certificate copy, for which he has filed prepared an appeal in the court below.
He said that he wrongly approached the court below, and thereafter realizing that appeal would lie to this court, then he withdrew it, and thereafter he filed it.
Because he applied for second certificate copy.
He has to apply it.
Both are affidavit in opposition. One against section 5,
Another, my lord, injunction, application for injunction.
All right. If I impose Can 2 of 2024. Both the appellant and the respondents are represented by their respective learned advocates. Stop. By filing the interim application being Can 2 of 2024 under section 5 of the Limitation Act, the appellant has prayed for condonation of delay of 92 days in filing the instant appeal. Stop. On perusal of the petition under consideration, petition under consideration, and after hearing the learned advocates for the contending parties, it appears to this court that challenging the impugned order dated 5/6/2023, the present appellant has approached a wrong forum. As per advice of the learned advocate for the appellant. Stop. Subsequently, such a wrong has been detected, and thereafter the instant appeal has been preferred. Stop. Under wrong forum
on good faith and the wrong advice,
for which he should not be victimized.
Therefore, the time consumed is liable to be exempted, or liable to be exempted under section of the
limitation. Stop. Accordingly, Can 2 of 2024 is allowed. Stop. Delay in filing the instant appeal is hereby condoned.
Office is directed to make a formal registration of the
And after is লিখে দেবে না, evidence in opposition as filed today on behalf of the respondent be taken on record.
that the respondent, the counsel for the respondent vehemently opposes the application. Yes.
Yes, my lord. The
41, let it
yes, my
appear.
lord. My lord.
Let it appear tomorrow as order 41. Tomorrow, order 41.
Let the matter be listed on tomorrow under the heading order 41 William Phipps.
Call the next.
My lord, in item number 26, my lord. Korban, 26 Korban. My lord, in item number 26, my lord, London Senior Counsel Mr. Probal Mukhopadhyay is appearing, my lord, but he stuck before the courtroom number 19, my lord, due to an ongoing parted matter, my lord. I am only praying for not today, my lord. My lord, I am the junior counsel. My lord, but
do it.
Facts you can place.
My lord, I cannot because my lord.
If you feel any difficulty, we are not going to dismiss in his absence.
My lord, I do not have the brief even, my lord, because I have already given the brief to him, my lord.
Sir.
No, I have, my lord, but the brief is with him, my lord. I have given the brief to.
Where is your brief, sir?
I do not have the extra copy, my lord.
Do you not carry? Then what junior you are?
My lord, kindly consider, my.
Have your own set of papers, and senior you should have given it to him, so that at least you will work over the brief.
I beg your pardon, my lord, but kindly consider, my lord.
This concept is very unknown to me.
My lord, I beg your pardon, my lord.
I was also junior at one point of time there. It's not that always one set is retained by the junior.
My lord, I am begging your pardon, my lord. For that, my lord, I kindly consider, my lord.
Should open the mouth, will tell us the fact. This is what they proved.
My lord,
You are unable to say simply depending senior has been engaged, so your responsibility is over. You do not have to go through the brief. You do not have to read the papers. Nothing. It is all the senior who will do it. Then what kind of assistance you are giving to your senior?
Item number 26 not to record.
Grateful, my lord.
Yeah, sir.
27 minute. Kindly see your lordship last order.
I appear for the appellant, my lord. Kindly seize my lord's order dated 19th of October, my lord.
Last order. Then no order can be passed today. Because that is the last order. No further order can be.
Last order passed in the matter. But till matter was hard.
The previous order,
Previous.
I can understand. The last order means there cannot be any further order.
That is my
This is that matter, my lord, between appellant. My lord, between the father and the mother was.
Who will speak?
Mr. Mukherjee senior to me, my lord. Mr.
No, I have to.
I was for the appellant, my
You are
lord.
a petitioner, appellant.
Appellant, my lord.
You have a right to begin under order 18 rule 1.
May I, my lord?
You do not know.
my lord, had taken up the matter on the earlier occasion. This is the matter between father and mother were the plaintiffs, and that the son was the one of the partners of the developing firm who were portrayed as the defendant. Now, my lord, kindly sees my lord's order dated 19th of October, where my lord had an occasion to interact with the father, my lord. My lord, there was an undertaking, and as per the undertaking, we have paid 10 lakh rupees as we undertook to pay by December, and we are paying the monthly rent, my lord. I have the documents to prove it. My lord, all I pray for the matter to be, since entire in the suit has been decided by virtue of my undertaking, my lord, that this be disposed of and the suit be disposed of by virtue of this order, man. That's all I pray, my lord.
I think virtually we have decided the suit. What
my lord?
Absolutely. Now what happened? They have taken the advantage. They did not pay the occupation. They did not pay the rent. Only when the matter was last occasion adjourned, this Sunday they paid the amount. Number one. Number two, একটু বলে নিবেন the thing is that there are three things. Number one, that after your lordship's order, they paid the amount up to September. Thereafter, our instruction, they did not pay anything. Now, my lord, when the matter was last
have been engaged recently.
No, I could not appear, my lord. Last time, Mr. Chatterjee appeared. Now, my lord, they are also there, my lord. They are junior, my lord. But last time I could not appear.
Led by Mr. Roy, my lord. I'm led by Mr. Roy.
Password was fought for on my behalf. Ultimately,
yes. What are the three things?
Number one, this is, my lord, only this Sunday they paid the amount. Secondly, my lord, if your lordship see your lordship's order, they will, my lord, give us 3 flats. Now, there are some divided portion, there are some regulated portion. In which portion they will give the flat, they have not yet mentioned. Number 3, my lord, we asked for a sanctioned building plan. Now, my lord, we requested them, they refused to give. We wrote to the corporation. Corporation said that I am not entitled to get the plan. Therefore, my lord, my first submission before your lordship.
What you will do with the plan?
Because, my lord, they have not specified in which floor.
If I correctly remember, you were not there. The time of interaction, your client's response was that he agreed for a particular area measurement.
Measurement which floor?
Appreciate. But in the plan, they have shown the lesser area. So I am not agreeable to it.
A plan subject to correction, my lord, subject to correction. I was not there, therefore I.
And either I am
Maybe,
not telling the truth. What I
absolutely no, I can't say that, my lord.
Your instruction is not correct.
I deem to my instruction is incorrect.
If I correctly remember, then I asked that what you really want. Then they say, so far as the internal arrangements are concerned, that can be taken care of. Then I suggested that if the entire floor is given to you, and thereafter, as per your suitability, you can ask for 4 flats, 3 flats, or whatever. That can be suitably done.
2 entire floors, man.
Now, which floor? If I put this question to myself.
When you raise that question, that the sanctioned building plan, that's the way I reacted. You are absolutely correct that which 2 floors. There was a suggestion from your client that which floor he wanted. Then it was that you take care of that, let it continue, which one you want. The son say, whatever my father wants, I will get.
Now situation change. Kindly see one. Now kindly see your lordship.
That day also it changed. The reason for change of the situation was well known to me. Because I find your client, when he comes and talks alone, he's the most sensible person to talk.
Still, my lord, I talk with the sensible person with my client. If your lordship see once, if your lordship
there is one thing which we notice, and we know what is the stumble block.
Kindly see your lordship's order and let them.
You want a solution. I told your client on that day that today you want an injunction. We will definitely uphold the injunction. No difficulty. The position is that the building has already been demolished. You are out of position. Would you want a litigation or you want an amicable solution? He suggested the solution. We accepted it.
Till we want. But we are, am I, if I permitted to put this question to myself?
Well, since my lord, my undertaking is on record, my lord, I'm acting as per my undertaking, my lord, let it be this. Let it be.
You should be very prompt in payment of the rental.
My lord, I tender my no, my lord, I tender my unconditional apology. There's a problem with the partners. We have tendered, my lord. We have, my lord. I have the related. There was a 1 month delay, my lord. I tender my unconditional apology because there was a problem with the partners. The signatures were required. There was a problem with the partners.
No,
my lord.
You have to do it.
I shall, my lord.
Indicate which floor. You indicate which floor. They will tell you.
My lord,
Tell us. You want
First and second floor, that was the initial talk. Let them say.
there was.
We have nothing to say.
first and second?
There was. There was nothing. My lord, kindly cease my lord's order dated second.
Was also present.
My client was present, my lord.
Agreeable. Now they say first and second. Give them.
My lord, kindly takes it up Monday to be as to be mentioned. Will.
So it come. Say first and second. Give. No further time.
Absolutely.
My lord, By virtue of the order dated 19th of October, we are directed to give an undertaking, my lord, we have given, but there is no order recording the undertaking has been taken on record. My lord, kindly records.
But if your lordship see once the order, once, please, one.
My lord, kindly cease.
For one. Thanks.
More open, widen your mouth more. I know who is the person giving instruction. I'm aware.
The plaint is quite clear who's giving instruction, the entire plaint.
Absolutely. The demeanor and the everything on the first day we have seen.
The pleadings are very apparent.
No. There are certain expressions which are used.
Right,
not,
my lord,
not,
absolutely.
Not acceptable.
My lord. That doesn't come from a father.
Should not.
Should not come from a father. My lord, kindly records that undertaking.
Cannot create a problem in your matrimonial life.
My lord. Aspersions and allegations, nothing has been left out. My lord, kindly records that. On the self-same date,
Only
the counsels appearing for the respective party. And it appears from the submissions.
But kindly record that they have paid only last Sunday.
Appearing parties that the fringe issues are still left to be addressed. And for that reason, the accommodation is required. Let the undertaking filed by the appellant in terms of the appeal order.
But 2 floor not mentioned.
Let this matter be let this matter be listed on Monday.
I'm grateful, my lord.
Under the same.
Grateful, my lord.
All points are kept open.
Undertaking, your lordship is saying that their floor has not been mentioned. My lord.
My lord, kindly seize the order for once, my lord.
It was not the talk at that point of time, sir.
My lord had.
Why I say you did not appear on that day. You had no knowledge of this.
Now you hard, my lord. If the
that is what a hearsay evidence is, the more dangerous evidence.
A building plan is, my lord.
Nothing, everything is known to you. Your client. Everything is known to
We
you.
have asked for the building plan, my lord.
My lord had directed unencumbered 2 floors. We have kept that open, my lord. My lord had directed. My lord, I shall take my lord.
No, we do not want to diverse what has happened on that day.
I'm late,
Come on that day, we'll see to
No,
it.
he said, I has come, my lord. Your lordship can take up.
No, let the clients be present because I cannot say which floor he wants to give because
you take instructions. It was agreed on that day. We do not want to say that what was agreed. You take, let us see that both the clients have
First and second.
respected for each other.
yes, undertaking there were 2 floors he will give. That was the only.
Suppose give the floor where the unauthorized construction. What I will do with
I
that
do not
floor?
know what type of submission is this.
English submission.
He's expecting that I am going to make an unauthorized construction. I am going to give the. Then what is the point of giving this undertaking?
Both of you are the trade mediator.
True. Yes, that is true. But this type of submission should not come that I am going to give him the unauthorized construction. Let it be.
Let him say something.
I'm good.
But from instead of Monday, my lord, can it be another day? From Monday to
Monday week.
There's a vacation, my lord.
kindly fix a date, my lord.
Kindly fixes a date, my lord. This can be disposed of.
On 8th.
I'm good.
But I'm being named. But he's on his way, my lord. Being led by Mr. Ali. He is arguing a matter, my lord, before Justice Ajay Mukherjee, my lord. He's on his way.
Names of the defendant number 3 in the degree of the trial court is not based in the certified copy of the appeal. Yes.
If your lordship admits it, my lord, your lordship would send it back for correction. My lord, the point of law, my lord, which your lordship will, which I, my lord, feel, my lord, is a substantial question of law, my lord, here.
Yes.
My lord, a tenancy,
Let us see.
where the tenancy cannot be created by a person who doesn't have the right to create. Because the degree has been granted. Not me, I'm the defendant. I'm the owner of the property. Possession, my lord, was never handed over to them. They, my lord, in the middle of the suit said that I have been dispossessed. When they were cross-examined, my lord, they did not produce a single paper saying that they were ever, my lord, in the business, my lord, in that property. The receipt which has been signed is being signed by the wife of the executor, of which, my lord, the probate was never granted. And the court says, grants a degree on the ground, my lord, that since there is a receipt, he's a tenant. My lord, he might have a better title vis-a-vis the person who gave him whatever that receipt was. But I, being the rightful owner, there's no dispute on that. I cannot be bound by that. My lord, today, in the property, my lord, which belongs to X, if Y grants, my lord, a rent receipt to Z, Y and Z, my lord, Y will have a better title than Z. But X cannot be, my lord, be bound by that agreement between Y and Z. That's the point before your lordship. And the court has granted a degree on admission. The rent receipts which have been, my lord, produced, the exhibits, are, my lord, the LTI, holds an LTI of Urmila. The person who has signed it was never examined. Urmila. And then there is an identification signature of a person, Becharam. Becharam was never, my lord, in any way, my lord, examined. He did not prove. Becharam, my lord, I don't, it's for the plaintiff to show, my lord.
Don't you know Becharam?
No. Becharam is nowhere to the property.
Why is putting a letter?
Not my wife. No, not my wife. My lord, the person from whom he has sought. From the person from he says that he has got tenancy, my lord. His executor's wife, Urmila Bagh. Urmila Bagh is not my wife.
Right.
That is my, I am the rightful owner. Since 1995, from the day, my lord, I have purchased the property.
From whom?
From the rightful owner, the Baghs. Naam to de. My lord, I am saying so, my lord. There is no question.
There is a will.
My lord, that will was never probated.
Who was the testator or testatrix of the will?
Satish Chandra Bagh.
So the persons who have sold to you, are they the heirs of Satish?
Yes, absolutely.
They are all the sons.
All sons, no dispute on that. My lord, my ownership, no dispute. It came from
An executor.
My lord,
Who was appointed as
the wife of Urmila. My lord, one.
Urmila is the female name.
Yes, she was.
Of Urmila, I do not know.
I'm sorry. The
wife of Satish.
Yes.
Wife of Satish. That is Urmila.
Yes. I bowed. Sorry, my lord. Youthful exuberance.
That's a compliment. Yes.
So this is the point, my lord. The facts of the last occasion were probably.
Who was this executor? What was his position?
He was
amongst the heirs.
My lord, the plaintiff's mother, she in a way inherited, my lord, from Satish Bagh. plaintiff's mother. She was the daughter, she was the wife of my lord, the original owner, Satish Bagh. Lord, your lordship need not, respectfully. I understand. That's why I want to make it clear. Yes, my lord. I bow down. If your lordship look.
Let me first reflect what I have understood. The property belonged to Satish Chandra Bagh. Satish Chandra Bagh died. Before his death, he made and published the will. First and foremost thing which I asked, that who was named executor in the will?
Parvati Bagh.
Parvati. What is his or her relation with the Satish Chandra Bagh?
He was the executor of his will. There was no relation as such.
Is this Parvati Bagh the son, daughter, or
no?
Anybody?
No.
No. So complete alien to a normal succession.
Yes.
So now, after this will was never probated.
No.
All the heirs treat that property to have passed through intestacy.
Yes.
They sold the property to you.
To first to the Bhakots, and then the Bhakots sold it to me.
Yes. That's the chain. Ultimately, it came to you. Yes. Now, this Parvati. Urmila is the wife of Parvati.
Yes. Yes.
Urmila executed those rent receipts.
Yes.
When Parvati was the executor. But Parvati did not apply for probate.
Was not granted. Probate was never applied for, never granted.
Unless it has been applied for, question of granting doesn't arise.
Yes.
So never applied.
Yes.
Till date.
Yes.
In the sale deed executed by the heirs of Satish in favor of Bhagat, whether this Parvati
No.
was a witness.
No, later. This happened later.
Parvati was a witness.
No. Milord, Urmila is Parvati's wife.
What is the school saying here?
I bow down.
She's not.
Urmila has been made party in the suit.
Yes. And Urmila, Milord.
No.
But in the memo of appeal, I do not find the name of Urmila.
Oh, she's passed away now. Heirs have been.
What is your relation with the? You are a dependent.
Yes.
What is your relation with the plaintiff?
Milord, my mother inherited something from Satish. No, not me. The plaintiff's mother. I have no relationship. You
are a purchaser.
I'm a purchaser.
You know something. I just wanted to create some kind of a link that if there is.
I also tried, but there is no link.
Now the plaintiff suddenly popped up in a more technological sense and claimed certain portion of the property as a tenant.
Yes.
Now, first thing is that the possession was parted with.
No, because he has filed, my lord, during the pendency of the suit, he says he was dispossessed. My lord, there is no pleading.
The possession.
No, there was not there.
Then the question of disposition.
Yes.
Repossession will come.
That's exactly my point before your lordship. There is nothing on record to show that he was in possession.
That's out of exuberance.
That's right.
Youthful exuberance.
Youthful.
I did not use that word.
I'm still pretty young.
So that is what I'm asking. Can he be able to prove the possession?
No.
Except the rent receipt, nothing.
Nothing. And electricity bill.
Have a claim to possession?
No. Nothing. I'm surprised that the learned judge said that this is a receipt.
Question arises that whether the alleged creation of tenancy by Urmila
creates a right.
The plaintiff,
yes,
in respect of the suit property, at all creates any power in the title of your clients. That is the question.
Let me heard on the following subsection. Whether both the courts below were justified in decreeing the suit solely on the basis of the rent receipts issued by a person who neither had any semblance of right title and interest nor the possession of any portion of the suit property. Next, whether both the courts below were justified in believing the genuinity and the authenticity of the rent receipt issued by a person having no semblance of right title and interest in respect of property. That too without corroboration of the left thumb impression by calling the witness who certified the same. Thirdly, whether a tenancy can be created by a person having no semblance of right title and interest in respect of a property. Beholds the persons being the owners thereof.
Look, execution has been levied. But for because there is a decree for recovery of possession. Title execution case number 40 of 2017. Yes,
we have this is an application for stay of the execution proceeding. Lodged on the decree having passed by the Court of Procedures, which is subsequently affirmed by the first. Since we have admitted the fee, if the position is allowed to be taken, it would cause immense injury to the appellants. Furthermore, since the respondent is admittedly out of position for a considerable period of time, and if the execution proceeding is allowed to continue, it would cause irreparable injury, and therefore the balance of convenience, and therefore on an equitable ground, the further proceedings of the execution case should remain in suspended animation. The application is disposed of with the direction that there should be stay of the operation of there should be stay of all further proceedings in
title execution case number 40 of 2017 pending in the court of the civil judge junior division additional court Tandon, arising out of title suit number 1. That's a Shubhra Kamal Mukherjee used to be very annoyed.
Till the disposal of the instrument.
Expedite
lower court record 1 week. Special messenger cost put in. Are you appearing for all the respondents, the plaintiff respondents? So we waive the service. Since have you got a Vakalatava? Can you give a caveat number?
88 of 20. Caveat has been received as your further.
Since the respondents have entered appearance in the instant matter, having lost the caveat, hearing number 88 of 2024 or 8/1/2024, that each shall be treated greatly as regards service. The Vakalatama annexed with the said caveat be detached therefrom and included in the instant appeal. The paper book is 4 weeks from date. Liberty to mention
Lord, my learned senior is here. Lord, there was one.
I'm sorry, my lord, I'm coming from 658. 652.
Lord, there's one humble prayer, Lord, which is being made by the civil bar. Lord, the problem with the civil bar is that every court, Lord, is scattered all over the Lord, the High Court. And it's becoming very difficult for the senior members, my lord, to, my lord, to attend, and honorable judges are very, very cooperative. But we also, my lord, feel at times that it's unjust on our part, my lord, to also, my lord, to pray for these adjournments all the time. If something, my lord, can be done from your lordship side, my lord.
From my lordship, kindly consider from 652, 652 to court number 25, court number 22.
The criminal courts are all together.
Court number 22.
The difficulty is so far as the writ jurisdictions are concerned. We can't.
Right.
And the difficulty another is that now somebody is totally confined to a civil matter. Somebody has expanded his horizon to somewhere else. So it is very difficult to combat these situations. We will definitely see that at least the order 41 page,
motion,
the motion, the page, so far as the revision
and second appeal.
Hearing is not. These two benches are together.
Second appeal also hears revisions.
No. No, that question, my lord. Lordship, kindly indulge me, my lord. This question arose while I was.
Same honorable single bench.
No, a question arise while I was the president of the bar.
There was a strike.
These questions cropped up. And that time, my lord, an adjustment has been made. And that was a battle between the, my lord, the bar library clerk and the two bar associations. But it was sorted out.
And there is another prayer.
But some people, they claim that this particular building is only for the original side.
Yes, there was a strike. My lord was with us at that point.
One of your lordship was.
Strike on that.
Yes, one of the main reasons on that.
Yes.
No, not on original side. About whether
the
judges
that your
will go.
lordship forgets that.
Whether the judges will go or the
But
files
these
will
are the difficulties we now face.
There is another prayer, with leave of my learned senior. My lord, the original side bar, the bar library has taken it up, and they have requested us also, my lord, to request your lordships about the senior gown. Lord, for 6 years, Calcutta High Court, my lord, your lordship is a part of it.
No, I'm not.
My lord, we are told that your lordship is a part of it.
No.
Indra Jackson's case of the Supreme Court, it is only the Honorable Chief Justice, the ED1, and that's all. And one member from the bar as the adequate judge.
I was asked, my lord, to mention it before your lordship that
Justice Das.
For 6 years, my lord, there has been no designation.
But I am not a part of it.
Then I stand corrected, Lord. I was requested that kindly, if you go, they are taking it up.
And two senior most judges. On seniority, only two judges. That's the 3%.
But even then, if your lordship has any opportunity, my lord, because only High Court now is Calcutta High Court. People junior to, forget me, everybody, my lord, I'm junior to everybody, but my lord, people who are 40 years old, 41 years old, outside practicing are senior advocates. Okay, just putting it in your lordship's mind. Grateful. Admit her, just stay. Go.
29, my lord, I'm for the appellant, my lord. Now, my lord, before placing the matter, my lord, I pray unconditional apology because there is a grave mistake in the memo of appeal. that the one of the co-defendant and my lord, the pro forma respondent, he has not been implemented as a party in the memo of appeal, my lord.
Then the limitation has intervened then?
Yes, my lord, because my lord, though the plaintiff have been made party, my lord, but the one of the co-defendant who is not contesting the suit, he has not been made party. It's a mistake, my lord, on my part, my lord.
Advocate and record.
And I am that.
Earlier matter also the same thing. I would suggest to the bar that we organize a refresher course for all those juniors to act as the advocate. Please, they should know the procedural law. You know the consequences, the serious consequences. We are not that strict and harsh. That's why you are getting an encouragement. Otherwise, the moment you leave it out, there is a judgment of our High Court that's and the Privy Council. It says that it is incompetent liable to be dismissed. Are you ready to face that? Leave is granted to the advocate record of the appellant to leave the left out parties here and now.
I shall.
Let this matter be listed on Monday.
Lodge. Lodge.
I'm for the appellant, my lord. There is a defect, my lord, regarding, my lord, that the certified copy of the decree of the trial court, my lord, my lord, that not that only the photocopy is given. Applied for lower court.
Not, sir. The formal rule is that the moment the appellate court has disposed of, you can make an application for return of the certified copy of the trial court for the purpose of preferring an appeal. And it is invariably granted by the first appellate. Why you have to apply afresh? Come on Monday, because it appears that another partner has heard this matter.
Regular bench. Yes, ma'am.
Today is an exception bench.
And the point is that of court form, my lord. Yes.
Next.
This matter, my lord, I am being led by Mr. Arijit Bardhan, my lord. If your lordship kindly take it up on one tomorrow.
One week.
Not this week.
Not this week. Next Thursday. Next Thursday. Adjourn for a week. Yes. Next. 32.
32, my lord, I beg to appear for the appellant, my lord. Mr. Hon'ble Chaudhary is leading me, my lord. He has now. He was waiting, my lord. He has now been on his leg on court number 7. 6.
You like to do it?
No, but there are some defects. Kindly grant me the liberty to. There was a caveat I've already served.
Pass the hurdle of admission.
My lord.
Caveat.
That's rule number 1. Differs from that of the difference. Send down to the code below for necessary information.
Doing the respondent number 1 is not matching with the names which are given in the decree.
No, there's a typographical error.
I do not know,
My lord,
but whatever you have to do it.
Well, I shall, my lord. Today, the first time appearing today, my lord. Kindly grant me the liberty, my lord, by advocate on record. I'll direct him. Today.
You have also advocate on record.
No, my lord, actually, my lord. Yeah, my lord, there is another connected appeal, my lord. Kindly, if that may be connected.
Leave is
Not
granted to
connected.
the advocate and record of the appellant to reach the effects pointed out by the staff reporter in course of this week.
I am so
This is the matter on Monday.
One minor indulgence, there is another second appeal, which is essay number 31 of 2024. These are the two suits were heard analogously as well as the appeal. Both the appeals are arising out of the same judgment ending.
Two decree, two appeal, therefore two second appeal.
Two second
But
appeals.
both the appeals are required to be listed.
May I kindly?
Numberটা দিয়ে দাও।
All the names.
Grateful.
I appeal for the appellant, my lord. There is a caveat, my lord. My lord,
There may be injunction or what?
stay application, my lord. Stay application, my lord.
It may arises from which?
Out of an order, my lord, whereby the respondent's application in order 39 rule 4 has been allowed, my lord. Vacating, my lord. My lord, suit for partition, my lord.
So you are the plaintiff.
My lord. My lord, suit for partition, my lord. My lord,
what was the nature of the impugn order, the injunction?
My lord, restraining the respondents.
That it are directed to maintain status quo with regard to nature, character, ownership, and position. Where is the vacating order?
My lord, one thing may I point out, my lord, after 2 days passing of this injunction order, my lord, some of the respondents appeared, my lord, and they filed an application under 39 rule 4. My lord, on the same day, my lord, this order has been modified without giving any opportunity of hearing to me and without giving any opportunity to file opposition, my lord. My lord, there was not an absolutely a non-speaking order. My lord, one more thing, my lord. My lord, one more thing, my lord. Subsequent to passing of this order, my lord, the same application was again taken for consideration. My lord, even the modified order was vacated by the subsequent order, my lord. Your lordship will find the order which, my lord, 18th October 2023 was the order when the injunction order was modified.
সেই করেছে কিনা ভগবান
Your lordship will not find any interim period in their order 39 4 application, my lord.
কিরকম সই আছে
In fact, in my respectful humble submission, my lord, the disposed of application was taken again for consideration, and in fact, the modified injunction order has been vacated. My lord, I called him, my lord, but he is not a regular practitioner. My lord, he gave me his address, my lord. I have sent the copies by post, my lord.
Again upon the parties.
My lord, there are 40 respondents, my lord. Only 2-3 respondents. One of the person has filed a caveat, my lord. One of the respondent, may I?
You want the contesting respondents.
It's respondent number 37 who has filed the caveat.
The trial court.
Yes, my lord.
Was the contesting respondent?
Order number 37, my lord. Defendant 37.
How many have appeared there?
20, 21, and 37. 3.
Serve at least 3.
Okay, my lord. Yes.
Appeal is admitted. The appellant is directed to serve the copy of this application upon the respondent number
20, 21, and 37.
20, 21, and 37. By the application.
My lord, one.
The service has been directed because despite the caveat having been lost, according to the learned advocate for the appellant, the lawyer who logged the caveat is not a regular practitioner of this court, nor has a place within the bar association.
My lord, he said he was under someone advocate, my lord, but he is not now associated with him, my lord. He gave me his postal address, my lord. I have posted the same, my lord.
Though the copy has been sent to him by post, but we feel that it would be better that copy is served upon those contesting respondents through the learned advocate who represented them in the trial court.
My lord.
Accordingly, the appellant is directed to serve the copy of this application upon the learned advocate who appeared for the respondent number 20, 21, and
37.
In the trial court. indicating that this matter would be listed on today's
14th.
28,
My lord.
8 March, 28.
28, my lord.
28.
My lord, one more thing, my lord. My lord, since these two orders have been passed under Order 39 Rule 4, my lord, I have taken out two appeals, my lord. My lord, that is running. There is a Section 5 application running in a lordship's list under the heading application, my lord. Let it be tagged, my lord. If a lordship says, then I will.
Let this matter be listed along with that matter.
My lord, I am handing over. I am handing over the number, my lord.
Second appeal has been preferred, challenging which order?
Second appeal, it's FMA.
FMA is second. No, second one.
Okay, vacate karo. Hold on, on the same application again vacate.
Without
Did it
hearing,
twice.
My first modified, second modification also been vacated. Without hearing, without anything, my lord. And sued for partition, my lord.
Yes, next.
Grateful.
Lord, then again.
My lord, your lordship may, in the meantime, my lord, because there are chances of.
Yes, please.
Okay.
We are keeping this matter on 28.
Grateful.
34 kindly makes it not to Miss Akanksha Mukherjee, the advocate on record. She has left the court, just has requested me to pray for an advocate. Miss Akanksha Mukherjee, a junior member of the bar, and I prefer not to.
I appear for the
Not today, my lord. She has instructed me not to.
Great. My lord, I appear for the respondent number 1 and 2.
Not today, personal ground.
Lord, can it be, my lord, subject to availability, my lord, can it be kept for Monday?
Monday.
My lord.
Not this week.
Obliged, my lord. Grateful, my lord.
দুটো অর্ডার করতে হবে আছে
Yes.
Lordship. This is a suit for eviction.
Defendant or
I'm the
plaintiff?
defendant, Lordship.
Tell us. On what ground?
Lordship, three folds of grounds, Your Lordship. Number one, Your Lordship, eviction notice has been not received by me, Lordship. The learned court below, as well as the first appellate court, holds that address is the same, so it should be deemed as a service.
Section 24 of the
Lordship, no.
General
Number two, Your Lordship, the rebuilding clause has been not, now gift has been taken place, Your Lordship. The suit has gift. On the basis of the gift deed, the plaintiff acquired the property. The suit has been preferred within 1 year of the gift deed transfer.
With the donor.
Let Lordship, check it out. Grandmother. The grandmother gifted the property in favor of the plaintiff. The plaintiff preferred the suit within 1 year from the transfer, and subsequently taken the clause of rebuilding in the suit. We have taken the point that the 1 year, the time frame of the 1 year, the learned court holds that the amendment took place after 1 year. So that point has been not taken into account. That the suit has been.
What was the ground for eviction? When
All this.
When the suit was initially filed.
Suit was initially filed on the grounds of default. Default has been not considered by the learned court below. Lordship, I am coming.
Default
Subletting.
Reasonable requirement, subtenancy. Now the subtenancy clause, your lordship.
Reasonable requirement, later on.
Later on. Subtenancy. Subtenancy, lordship. Lordship.
Then later on, by way of an amendment,
rebuilding,
incorporated building and rebuilding and reasonable requirement.
Reasonable requirement was first of all. There was from the beginning, your lordship. And the subtenancy, so far as the subtenancy is concerned, your lordship.
One ground is sufficient. Your point is that they have said that the amendment came after 1 year. So
that should be taken into account that the suit has been filed after 1 year. That point has been not considered.
Now consider.
But is there any issue to that effect regarding building and rebuilding?
Lordship.
Are you aware of a division bench judgment of our High Court in Uma Sannyal's case?
That is there, lordship. Now so far as the subtenancy is concerned,
the coordinated bench.
No, so subtenancy is concerned, your lordship. I have
only one ground is sufficient. If he is able to prove the reasonable requirement or a building and rebuilding, even if he has failed to prove the default or a subtenancy.
In the subtenancy is, so far as myself is concerned, your lordship, it is a.
That's all. Amendments out of 42 cases. It also
that will not relate back to the idea of institution of the suit.
Both the points.
Subtenancy is concerned, your lordship. My brother is there, your lordship.
There is the judgment of the Supreme Court. If the third person is found to be in possession, then it is the duty of the tenant to explain that in what capacity is there.
My brother is there, that's it. And that is admitted in the plaint also.
Married or unmarried?
Lordship, married. Married.
Have another zone accommodation.
Yes, I have an accommodation. Lordship, that is there, your lordship.
So it has been decreed on various grounds.
Altogether it has been decreed, your lordship.
Then? Which one? আসুন তাহলে। In this appeal, the judgment dated 12/10/2023 as passed in title appeal number 131 of 2022 by the learned additional district judge, Second Court, Howrah, has been assented. Stop. While disposing this said appeal, the learned First Appellate Court affirmed the decree of eviction of a tenant as passed by learned civil judge within bracket Junior Division 7th Court, Howrah, in title suit number 264 of 2019. Stop pad. From the photocopy of the judgment as has been impugned before the learned First Appellate Court, it appears to us that a suit for eviction under West Bengal Premises Tenancy Act has been filed against the defendant who is appellant before us on various grounds, namely defaulter in payment of rent, comma, reasonable requirement of the suit property of the plaintiff for his own use and occupation and his family members, comma, the defendant has his own property within 10 kilometers of the suit property or within the same municipal corporation area, and also on the ground of building, rebuilding, etc. Stop. In course of his submission, learned advocate for the defendant appellant contended before us that the view taken by the learned trial court regarding sufficiency of service of notice of eviction upon his client has been wrongly assessed by the learned trial court in view of the fact that before the learned trial court it has not been proved that actually such notice has been served upon the defendant. Stop para. On perusal of the copy of the judgment as passed by the learned trial court, as well as the judgment as passed by the learned first appellate court, it appears to us that both the courts below have rightly come to a conclusion with regard to the sufficiency of service of notice upon the defendant appellant herein by applying the provisions of section 24 of the General Clauses Act, in as much as both the courts below have come to a concurrent finding that the said notice, that the envelope containing the said notice of eviction was correctly addressed and it has been prepaid. And the postal charges have been paid thereupon. Correct postal charges. Correct postal charges have been requisite. Yes, stop. Stop. So far as the grounds of eviction are concerned, we found that before the learned trial court, the plaintiff had adduced sufficient evidence that he requires the suit property for his own use and occupation as well as for his family members. And such factual finding has not been altered even before the first appellate court. Stop para. So far as the ground of building and rebuilding is concerned, learned advocate for the appellant before us contended that since the plaintiff before the learned trial court was a purchaser of the suit property, he cannot take this ground for eviction till the statutory period of 1 year, no?
Lordship.
Still the statutory waiting period of 1 year is over.
The argument is differently. The appellate court has said that the trial court on the ground of building and has held in your favor.
No.
Yes. It's barred in the 6-2.
6-2.
So he has held in your favor as a
Held in my favor. Subsequent to that,
and the rule. Actually,
reasonable requirement
was lateral
requirement has been made.
Amendment.
But building and rebuilding was already there. And then the court has held that since it is within 1 year, so
He is not entitled to it, but
in his favor.
in his favor. What about the stop para?
Reasonable requirement has been considered.
Sorry, you said
And the
building
tenants
rebuilding subsequently introduced. No. But I find from the judgment, no. And rather it goes in your favor. Wrongly goes in your favor. Anyhow.
হ্যাঁ ওটা ঠিক আছে সলভ আছে ট্রায়াল করে জাজমেন্ট আর রাখা কি বলছে
page 13, internal page 13 and page para 23.
এটা ওটা কি বললাম বলুন তো হ্যাঁ so far as the ground of reasonable requirement so far as the ground of reasonable requirement is concerned no এবার বাকিটা ওটা কেটে দিই since it has been observed by the learned trial court that the plaintiff is a practice acha telegram stop it appears from the record that the plaintiff is a practicing advocate of Howrah Bar and he with his family members are staying elsewhere apart from his own house, and it is the further case of the petitioner plaintiff before the learned trial court that in the event he gets possession of the suit property, he could stay there, which would not only save his time, but also the same would be convenient for him as well as for his wife and the little child who is growing day by day. Stop. It appears to this court that learned trial court has apprised this fact on the basis of the evidence of the plaintiff as well as on the basis of the evidence as adduced by PW2 within bracket learned commission vis-a-vis the inspection report as submitted by the said commissioner being exhibit 12 series. Stop. Such continuation, such factual finding is found to be before the first appellate court also. Para deben. কোথায় বলেছে বলতো একটা একটা আর একটা জায়গায় ওর একটা বাড়ি আছে সাবলেটিং করেছে সেটাও বলেছে একটা
Page 13, para 23, Your Lordship. Respondent is a practicing advocate and he needs the tenanted premise and own occupation. Being the landlord, he can understand.
Purchase a flat in the name of your wife, you are residing. What?
Stop.
Why you want to stick on them? Go, live there.
So far as the ground as mentioned in section 6(1)(c) of the West Bengal Premises Tenancy Act 1997 is concerned, it is the case of the plaintiff that the defendant and his wife are now residing in a newly purchased flat at 49/2 Makorda Road, Howrah. To substantiate his contention, the plaintiff before the learned trial court has exhibited one purchase deed one deed of conveyance in the name of the deed of conveyance in the name of defendant's wife. Stop. while appreciating the evidence as adduced by the parties, learned trial court is found to be correctly assessed the evidence and come to a finding that since the wife of the defendant is a housewife and has got no independent income of her own, an inference can be drawn that it is none but the defendant who has practically funded না এটা ডিফেক্ট হয় এটা আসলে ট্রায়াল কোর্টের ফাইন্ডিং করছে
simply based on grounds for the execution restrict has correctly assessed the evidence.
না দরকার নেই that the defendant is residing elsewhere.
That the defendant has the separate piece of
accommodation by abode
and non-disclosure invites an adverse inference to be drawn against.
Stop.
That the claim for reasonable requirement was founded upon the assertion that the plaintiff is residing in the house of his father as a licensee and have acquired the right title and interest in respect of the premises on the strength of a deed of gift executed by his grandparent. Does not appear from the record that the plaintiff has in of the other house belonging to the father as he is still alive. Furthermore, it is if the plaintiff intends to live in his own house along with the family, the law does not put any deterrence nor an obstacle in achieving such object which appears to be laudable and reasonable. Furthermore, between the court and the premises is in the close proximity, and therefore the plaintiff shall be able to run the chamber from premises, and therefore we do not find that such need can be termed as a mere wish or a desire.
It only is reasonable requirement with the aforementioned finding. With the aforementioned finding, with us hold that the instant appeal in favor of the and is thus dismissed. We thus do not find any substantial question of law involving the instant appeal. Involving the instant appeal is dismissed.
Okay.
Miller, one kind accommodation. Today is 36. Next item is mine. Tomorrow it is possible. It is difficult today. Huh?
Let us do it today. Do it. We'll take up. Don't. Yes.
Order 9, Rule 13, that was dismissed by the lower court.
My lord, I am appealing for the respondent husband, my lord.
Appeal.
Huh?
Appeal. Order 9, Rule 13 dismissed by the trial court. Appeal.
Appeal is made against that order.
Yeah.
Yeah.
First time.
First time. It has been heard by your lordship. It has been heard by your lordship.
Five.
Huh?
Section
Then 5 has been given, has been accepted by.
Section 5 allowed.
Allowed by this code, not that. That is to be heard. That is to be heard.
My lord, only one thing, my lord. My lord, another item number 37. It appears from the causes it is a related matter, my lord. But let a copy be served, my lord.
Yeah,
I do not
actually,
know what is there.
Come on Monday.
My lord, Monday, my lord, can be taken on Tuesday, my lord. My lord, on Tuesday.
Tuesday.
Grateful, my lord.